All right. Good morning, everyone. I see we are recording and we are streaming. So I am going to go ahead and convene this evidentiary hearing, and we are on the record for KGS Financial Plan in the matter of the investigation into Kansas Gas Service Company, a division of One Gas Inc. regarding the February 2021 winter weather events as contemplated by docket number 21 GIMX 303 MIS, docket number 21 KGSG 332 GIG. As you all know, due to the pandemic, we are conducting this hearing via Zoom, and we are broadcasting to the public on YouTube. So please do bear with us if you experience any technical difficulties. I am going to begin with entries of appearance, and we will start with Kansas Gas Service.
Good morning, Commissioners. James G. Flaherty, Ottawa, Kansas, and Kelly A. Daly on behalf of the applicant, Kansas Gas Service.
Thank you. Morning, Jim.
Morning.
Symmetry.
Good morning, Chairman French and Commissioners. This is Andrew Schulte with the Polsinelli Law Firm on behalf of Symmetry. Also here today on behalf of Symmetry is Frank Caro with Polsinelli, as well as Catherine Sawyer and Margaret Tuff with the law firm Latham and Watkins.
Thank you. Good morning, Andrew. Atmos. Do we have Ed Peterson for Atmos? All right, we will move to Freedom Pipeline.
May it please the Commission, Kyler Weiniger on behalf of Freedom Pipeline.
Good morning, Mr. Weiniger.
Good morning, Chair French.
Blue Mark, Wood River.
Good morning, Chairman and Commissioners. My name is Alex Goldberg with the law firm of Evershed Sutherland, here on behalf of Blue Mark and Wood River.
Morning, Mr. Goldberg. Wichita Diocese, Foley, and Central Christian.
Good afternoon, Mr. Chairman. First of all, I apologize for not being in a tie this morning. That is meant to be no disrespect to the commission. My name is Ed Watson, C. Edward Watson, and I'm here on behalf of Bonavia, the Catholic Diocese, Temple Live, Foley, and Central Christian Church.
Thank you, Mr. Watson. And you're going to have a hard time getting me to complain about no ties. So
that's why I targeted you.
Chair French, Mr. Watson's joined us, so if you want to reread.
Oh, you mean Mr. Peterson?
I mean, Mr. Peterson, I'm sorry.
Can we get an entry of appearance from counsel for Atmos?
Yes, Mr. Chairman, Ed Peterson appearing on behalf of Atmos Energy Corporation.
Thank you. Good morning, Mr. Peterson.
Good morning.
Good morning. NGTCC.
Good morning, Chair and the Commissioners. This is Jim Zakora, and I'm appearing along with Connor A. Thompson on behalf of the Natural Gas Transportation Customer Coalition. That's a lot to say. And our listed clients are included in a pleading which we filed with the Commission on October 7, 2021. Thank you.
Good morning, Jim. Constellation.
Good morning, Chair. This is Joshua Harden on behalf of Constellation New Energy Gas Division, LLC, with the law firm of Collins & Jones.
Morning, Mr. Harden.
Morning.
Kansas Attorney General's Office.
Good morning. This is Melanie Jack, Assistant Attorney General for the Office of Attorney General. Thank you.
Morning, Ms. Jack. Curb.
May it please the Commission, this is David Nicholl, Consumer Counsel, and I have with me Joseph A. Strab on behalf of CURB.
Morning, David.
Good morning.
And finally, Kansas Corporation Commission staff.
Good morning, Commission. Terry Pemberton appearing on behalf of the Commission staff and the public generally.
Morning, Terry. All right, I believe we have all the entries of appearance, so let us move to notice of this proceeding. Does staff have a recommendation regarding notice?
Yes, we do. The Commission issued an order, a procedural order on November 30th for KGS's financial plan, which is the subject of today's hearing. That order set a hearing for today's date at 9 a.m. to be conducted via Zoom. The order was properly served on all parties to this docket. We subsequently conferred as a group at a pre-hearing conference to discuss procedure relating to today's hearing. Therefore, staff recommends a finding that notice is proper and that the commission has jurisdiction to hear this matter at this time and place.
Thank you. Are there any objections to notice? Hearing none, I will find that notice is proper and the commission has jurisdiction over this proceeding at this time and place. We will now move to some preliminary matters. I understand the parties have a few, but before we turn to those, just a few guidelines and reminders for how we will conduct the hearing via Zoom. First, if any party encounters any technical issues today, I will just ask you to please let us know, and we will go off the record and resolve the technical issues before coming back on the record. Second, witnesses participating via Zoom are asked to keep their microphones off when they're not scheduled to talk. That pretty much goes for everyone, please. Third, if the commission needs to deliberate, we'll be going off the record, entering a Zoom breakout room where you can't see or hear us, and then we will be returning from that breakout room. And finally, since we're participating at a distance, please be especially careful to identify exactly what you're referring to when you're discussing pre-filed testimony or exhibits. I believe we all have copies of those items on hand, so we should be able to follow along if you will specifically identify what you're referencing. Now moving to our other preliminary matters. First, I understand the parties wish to go ahead and wave into the record certain pre-filed testimonies. Is there one party that wishes to make that presentation?
Yes, Your Honor. This is James Flaherty. On behalf of Kansas Gas Service, we would request that the public and confidential pre-filed direct testimony and exhibits of the following KGS witnesses that filed their pre-filed testimony on July 30th, 2021 be referred into the record. That's the testimony exhibits of Sean Postlethwaite, Matt Robbins, Mark W. Smith, and Bernadette Johnson.
Is there any objection? Hearing none, the referenced testimonies will be admitted into the record.
And I believe Mr. Zakura has testimony that he needs to refer into the record as well. I'll let him do that.
Okay.
Good morning, Chair French.
Good morning.
At this time, we would respectfully request that the testimony of Michael Gorman filed in support of the settlement please be admitted as evidence in this proceeding.
Are there any objections? Hearing none, the referenced testimony will be admitted into the official record. Is there any additional evidence that needs to be waived into the record? I believe that covers everyone that's not testifying live, but speak now or forever hold your peace if there is not anybody else. All right. With that, I have an additional preliminary matter. I understand that Symmetry and the parties have reached a procedural stipulation in this case, and I believe Symmetry will be presenting that to us. Mr. Schulte, is that correct?
Yes, Chairman French. We have a stipulation that came out of the December 13th pre-hearing conference, and it was filed in this docket this past Wednesday. December 15th. And it's not very long, so I can read it into the record if you would like me to. It's also on file with the commission, so however.
It's on file, so I have it in front of me. It's on file. If you would maybe just summarize within a couple sentences what it purports to do and how it affects the scope of today's hearing or the examination of witnesses in today's hearing, I think that would be helpful.
Certainly. So there was a testimony deadline for parties to file in opposition to the settlement before you today in the financial plan proceeding. And that deadline was this past Monday, December 13th. There is also in this same docket a waiver proceeding, and there's a testimony deadline on Monday in that waiver proceeding. So rather than file testimony twice, the parties agreed that Symmetry would file testimony once on Monday. Symmetry has reserved its right to argue that the commission should consider the testimony that it files on Monday when considering the settlement in the financial plan proceeding, which we're here to talk about today. So we've reserved that right. KGS has reserved a right to argue that the scope of our testimony should be limited. And all of that is laid out in the stipulation set forth and filed on December 15th.
I noticed that, let's see, number 3 on page 2 of the stipulation states that KGS will make available for cross-examination in the waiver proceeding all witnesses who presented written testimony in support of the financial plan that we're considering today. Does that mean that the scope of cross-examination today is limited and that those questions would be held until the second evidentiary hearing?
That's correct. Thank you for raising that, Chairman French, because yes, there is the other piece of the stipulation is that Symmetry will take a limited role in today's hearing regarding cross-examination, since there will be another hearing in January, and we will participate fully in that in January.
Okay, very good. Anything to add by any other parties to the stipulation?
Yes, Your Honors, Jim Flaherty. Just to indicate that the Kansas Gas Service has set forth its reservations in that stipulation and would ask the commission to take note of those reservations. Thank you.
All right, thank you. Are there any other preliminary matters the parties wish to address before we proceed to examination of witnesses?
Chairman French, just one other thing. We may have some follow-up questions if there's something that is raised by commissioner questions. So I just wanted to note that at the outset. We don't plan on providing any we don't provide any initial cross, but if there is something that's raised that we feel we need clarification on, we may have a follow-up.
Okay. All right. Well, I said examination of witnesses, but actually next we're gonna look at opening statements. So I do understand we've got several parties slated to make opening statements, and on my list I show Kansas Gas Service will go first, followed by Curb, Symmetry, and then KCC staff. And following opening statements, we will move to examination of witnesses. I understand that in the pre-hearing conference, the parties did indicate that they do not anticipate making closing statements, but we do have a procedural schedule that allows for post-hearing briefs. So moving to opening statements, I have Kansas Gas Service and Mr. Jim Flaherty first.
Yes, good morning. And Michelle has been gracious enough to run my PowerPoint presentation for me. So Michelle, if you could put that up. And while she's doing that, I did have one other preliminary matter, and that's to give my condolences to the attorneys from Los Angeles who are in this hearing today to the football game last night and the Kansas City Chiefs taking care of the Chargers. So good morning again. The parties are here to present to the commission for its review and approval a settlement on KGS's plan to minimize the financial impact to its sales customers relating to the extraordinary cost incurred during Storm Uri in February of 2021. Michelle, could you move to the next slide, please? The table on slide 2 can be found in the pre-filed testimony of Matt Robbins at page 8 of his testimony. KGS sources its gas supply upstream of its city gates from 12 pipelines made up of the 8 interstate pipelines and the 4 intrastate pipelines listed in this table. As Mr. Robbins explains in his testimony, KGS obtains its gas supply for its 648,000 sales customers from suppliers who obtain their gas supply from gas fields located in southwest Kansas, northwest central Oklahoma, and the Rockies that are connected to the pipelines that are listed on this table. What's important to point out is the top line of the table shows that nearly 80% of KGS's sales customers are served off of the Southern Star Interstate Pipeline. Mr. Robbins, in his testimony at page 9, also discusses the types of gas storage services that KGS has contracted for its sales customers and which are paid for by KGS's sales customers. Mr. Robbins' direct testimony at page 22 identifies the unforeseen and unprecedented spike in natural gas prices that occurred during Storm Uri. To place those extraordinary gas costs in perspective and layer on top of those extraordinary gas costs the significant increase in demand for gas because of the extremely cold weather conditions, two facts in the pre-filed testimony stand out. First, with respect to demand, as pointed out by Mr. Robbins, during a typical February day, the throughput on KGS system is about 478,000 MMBTUs. During the 9 days of Storm Uri, which were February 11th through February 19th, the average daily throughput nearly doubled to 921,494 MMBTUs. With respect to the gas cost that KGS incurred on behalf of its sales customers during Storm Uri, and again, in putting that in proper context, in February of 2020, KGS's total gas costs were $23.8 million. In February of 2021, during Storm Uri, total gas costs incurred by KGS were $391 million. Michelle, if you could turn to slide 3, please. As you know, the commission asked KGS, along with the other utilities impacted by Storm Uri, to file a plan to recover the deferred extraordinary gas cost and other extraordinary costs in a way that would minimize the financial impact to customers and the utility. KGS filed its original financial plan on July 30th of 2021. KGS explained that under its proposed plan, it would take advantage of the 2021 Kansas legislature's Kansas Utility Financing and Securitization Act. And if the plan was approved by the commission, it would then apply for a financing order in a separate docket. And if that financing order was approved, that would allow KGS then to recover what the act refers to qualified extraordinary costs through the issuance of securitized utility tariff bonds. KGS's plan identified and quantified the qualified extraordinary cost to be financed. That can be found in Ms. Buchanan's direct testimony at page H. Those costs included approximately $373 million in deferred gas costs and $8.3 million in other extraordinary costs, excluding carrying costs. KGS's plan also included recovery of carrying costs on the deferred cost, and pursuant to the commission's February 15th, 2021 emergency order issued in the 21-303 docket, KGS used its weighted average cost of capital to calculate the carrying charges on the deferred amount for the period between when the costs were incurred and when the bonds would be issued. And that carrying cost was estimated to be $70 million. KGS also allocated the deferred cost and carrying charges to customer classes based upon each class's February 2021 actual usage. KGS's plan called for using the reconciliation process set forth in the act to credit customers for net penalty amounts recovered after the bonds were issued, net disputed purchase gas cost invoices, and any relief obtained and received by KGS relating to actions taken by FERC and the Kansas Attorney General's office regarding profit disgorgement, civil suit relief, and market manipulation findings. Michelle, next slide, please. In support of KGS's financial plan, it's submitted the testimony and exhibits of those persons listed on this slide. The testimony and exhibits have been referred into the record this morning by the commission and provide substantial competent evidence, both factual and expert testimony, that supports the settlement on the financial plan that is being presented to the commission today. Michelle, next slide. Slide 5 shows the estimated monthly impact to residential and small commercial customers as set forth in Janet Buchanan's direct testimony at pages 17 and 18 under a number of different scenarios using the qualified extraordinary cost and KGS's weighted average cost of capital that were included in the original plan. Taking a look at this slide, if KGS were to use a traditional rate making approach to recover the deferred cost and amortize those costs over 3 years, as shown at the first line under each of the residential and small commercial customer as set forth in this slide, the deferred cost, the impact to the residential customer would be $17.51 per month. By using securitized utility tariff bonds issued under the Act with a 10-year term, KGS will be able to reduce the impact to a residential customer down to about $6 per month for the first year, and then that amount is reduced gradually over the 10-year period to $5 per month for the last year. It's important to point out that in looking at the numbers on this slide, that these impact numbers will be less under the financial plan that was included in the settlement, because KGS has agreed to reduce the carrying charges from $70 million to $15 million. It's roughly about $1 per month less under each scenario, but Ms. Buchanan has those numbers. If the commission wishes to ask her, she can provide those to the commission for the record. She will also have available, if the commission is interested, in the credit that sales customers would receive if KGS is successful in obtaining the penalty amounts from marketers that are set forth in the settlement in the waiver proceeding. And that would reduce that amount, for example, the $630 for a residential customer, about $100. And again, she can explain in more detail what impact that has. One of the other numbers I want you to remember for this slide is that $630 number that relates to the extraordinary cost a residential customer is being asked to pay, because I think it's important to place that amount in perspective as well. And I'll have more on that towards the end of my opening statement. Slide 6, please. Pursuant to the procedural schedule issued by the commission in this docket, all of the parties conducted and participated in a technical and settlement conference that resulted in several virtual meetings and the settlement that was filed with the commission on November 19th, 2021. The main terms of the settlement are set forth in this slide, and then the following slide in slide 7. The settlement on the financial plan is supported by, or not opposed by, all the parties in this docket except Symmetry. The settlement states that the $316.16 million in qualified extraordinary costs that are set forth in detail in Appendix 1 to the settlement were prudently incurred and subject to those costs being updated, trued up, and verified in the separate docket regarding the financing order, shall be financed by KGS applying for the issuance of securitized utility tariff bonds under the Act. The settlement also allows for KGS to recover carrying charges at a rate of 2% on the qualified extraordinary cost, again, from the date that those costs were incurred until the bonds are issued. Lowering the carrying cost rate from KGS's weighted average cost of capital to the 2% reduces carrying charges from $70 million to $15 million. Issues relating to such things as the terms of the bonds, the securitization utility tariff charge, whether that would be recovered from customers using a fixed charge or a volumetric charge, have been deferred to the separate docket regarding the financing order. The disputed Macquarie gas supply invoice, which is discussed in Mr. Robbins' testimony, has been removed from the gas costs listed in Appendix 1 and will be treated separately. If the dispute is resolved prior to the application being filed for the financing order, then the gas cost paid to Macquarie, if any, will be included in the gas cost being financed by the bonds. If the dispute is resolved after the application is filed, then costs relating to the dispute, again, if any, will be recovered either through the COGR, ACA, or deferred and recovered in KGS's next rate case. In slide 7, in the event that KGS receives any funds as a result of profit disgorgement, civil suit relief, or market manipulation due to state and federal investigations, those funds will be passed on to customers through the company's COGR ACA on an annual basis. Provided that such is allowed under the Act, the securitization utility tariff charge will not be charged to transportation customers because they are not considered retail customers under the Act. By December 31st of 2022, KGS will propose a tariff to assist low-income customers in paying their gas bills. Carrying charges applied to penalty amounts set forth in the settlement on waiver have also been reduced from KGS's weighted average cost of capital to 2%. KGS's sales customers who intend on becoming KGS transportation customers shall be required to pay a conversion fee based on the net present value of expected charges that customers would have finally paid as a sales customer. Finally, in anticipation that Symmetry plans to discuss its involvement in this proceeding relating to KGS's financial plan in its opening statement, KGS would like to mention a few things on that subject. If Symmetry believes the proposed penalty it is being assessed under the settlement agreement in the waiver proceeding is too high, and although frankly, Symmetry should be thankful that the penalty for it failing to provide gas to its transport customers during Storm Uri is as low as it is under the settlement, because it would have been significantly higher if KGS had not sought to waive the multipliers in the tariff, which I've heard several parties in this case over the last few months refer to that situation as no good deed goes unpunished. Subject to the reservation language contained in the stipulation that was filed this week, Symmetry will have the ability to challenge the reasonableness of the penalty amount it should have to pay for failing to provide gas to its transport customers during Storm Uri in the waiver proceeding, and that hearing set for January 19th and 20th. What Symmetry does not have the legal right to do in this docket is to challenge the reasonableness of the settlement relating to KGS's financial plan to minimize the financial impact of Storm Uri on it and its sales customers. A financial plan that, again, has been agreed to or is not opposed by all the parties in this docket except Symmetry. Nor does Symmetry have the legal right to delay and interfere with the approval and implementation of KGS's financial plan in any way, and in particular, delay and interfere in such a way that would result in KGS's sales customers not being able to take full advantage of the current financial markets in obtaining favorable terms for the securitization bonds. The basis as to why Symmetry has no legal right to challenge the reasonableness of the settlement on KGS's financial plan is simple. The financial plan is outlined in the settlement that is before the commission today for approval only pertains to KGS's sales customers, and Symmetry is not a KGS sales customer. The plan sets forth how KGS intends to minimize the financial impact to its sales customers relating to the extraordinary cost incurred and deferred by KGS on behalf of its sales customers, so its sales customers would not lose gas service during Storm Uri, and so its sales customers could avoid, most importantly, risking loss of life and health issues, and could avoid incurring billions of dollars in property damage to their homes and businesses caused by frozen and broken water pipes. If you recall, I said I would come back to that $630 that residential customers are being asked to pay for gas they received during Storm Uri. It's important to place that $630 in proper context. Without gas service, Kansas residential and commercial customers could have been looking at thousands of dollars in property damage to their homes and businesses caused by frozen and broken water pipes because those customers were without heat during the extreme winter storm. Kansas was lucky because utility customers did not lose electricity and did not lose gas needed to heat their homes and businesses. Persons in Texas were not so lucky because they lost their electricity and they lost utility service needed to heat their homes and businesses. The state of Texas did an analysis of the loss of life and the amount of property damage to homes and businesses due to the lost utilities and frozen and broken water pipes. The study showed that billions of dollars in property damages were incurred. If the commission is interested in that, Ms. Buchanan has reviewed that study and can answer any questions. The point is, and the reason why I bring that up, is that when a reporter or legislator asks, how is it reasonable for Kansas utility customers to have to pay $600 for gas service last February to heat their homes, or $1,200 to heat their businesses, and setting aside the matter of avoiding loss of life, which is priceless, the answer should be to compare that $630 or the $1,200 to the thousands of dollars in property damage that those residential customers and those businesses avoided by being able to keep their utility services on during that extreme winter event, and them not having to deal with broken water pipes and the property damage those broken water pipes would have caused to their homes and businesses. Back to symmetry, and I'll finish up. Here are the uncontested facts in this case as it relates to symmetry. KGS only buys gas for its sales customers. Symmetry is not a KGS sales customer. KGS does not buy gas for Symmetry. The financial plan only pertains to KGS sales customers. The financial plan does not pertain to Symmetry because it is not a KGS sales customer. KGS is not asking Symmetry to pay for anything under the financial plan because Symmetry is not a sales customer. KGS is only asking Symmetry to pay a significantly discounted penalty under the KGS tariff that required Symmetry and the other marketers to supply to their transport customers during the period when operational flow orders or periods of curtailment were called by KGS pursuant to the tariff, and Symmetry and those other marketers violated that tariff. All of the parties in this case that do represent KGS sales customers, those are KGS, staff, and CURB, all have approved the settlement on the financial plan. Finally, it is fair to question the motivation of Symmetry in this case, especially given the detrimental impact that could result to KGS and its sale customers should approval and implementation of the financial plan and the issuance of securitization bonds be unreasonably delayed due to the actions of Symmetry in this case. KGS will certainly address that issue in its post-hearing brief. Let me close by indicating that KGS believes that the terms of the settlement on the financial plan are reasonable because they will minimize the financial impact on our sales customers while allowing KGS the opportunity to return its credit metrics to pre-winter storm Uri levels in a reasonable period. KGS and its customers appreciate the work performed by the Kansas legislature earlier this year in passing into law the Securitization Act and the governor for signing the law. The legislatures and the governor's swift actions in response to the unprecedented storm will clearly result in minimizing the financial impact on customers and KGS. So the legislature and the governor should be congratulated and take some well-deserved credit for enacting a procedure that will clearly minimize the impact to KGS's customers. KGS also appreciates all the work performed by staff and CURB in this docket in reaching a result that will minimize the impact on customers and KGS. Your staff and CURB also should receive a lot of credit for their actions in this docket. KGS would request that the commission approve the settlement on the financial plan. It is supported by substantial competent evidence in this record, and it will promote the public interest.
Thank you, Mr. Flaherty. I have next on my list, David Nicholl from the Citizens Utility Ratepayer Board. Morning, Mr. Nicholl.
Good morning. May it please the commission, Dave Nicholl on behalf of CURB. I would like to start by framing CURB's response this morning, or its opening statement, in connection or in conjunction with the stipulation that Symmetry has filed. I understand that there are 3 issues that Symmetry is asked to weigh in in this docket, as well as the hearing on the limited waiver of the tariff. And that is with regard to prudency, with regard to carrying cost, and with regard to rate case cost. I will not address those this morning, and will reserve the right to address those particular concepts at the time that we have the second hearing in view of the full evidence on the record. At the outset, I'd like to address 3 questions that the commission, I think, may have for CURB. I'll promise to do my best to answer those questions. I can't promise that I'll do as well as Josh France did in the earlier hearing, but here goes. The first question the commission had was the number of contacts that CURB has had from customers with regard to Winter Storm Uri. And there were quite a few. Initially, we had some questions on people that were concerned about what was going to happen. And then eventually we started to see questions from non-jurisdictional customers, mostly a few jurisdictional customers, but mostly non-jurisdictional customers, because they were receiving bills from their carriers, municipalities and the like. They called because of the shock of the bills. They called because they did not know what to do. They called with various confusion, and we did our best in conjunction with the KCC, PACP to try to answer those questions. We did not receive a whole lot of jurisdictional questions, and our supposition is that's because jurisdictional customers had yet to receive any bills. We do anticipate that when bills start to come out after the Winter Storm Uri hearings, that we will see an influx of those types of questions. And in our view, it's absolutely imperative that we get ahead of those. So that's the next question that the commission had for us is, what are we going to do with regard to outreach? And that is a really important question. There are going to be people, ratepayers that don't understand, that are going to need help, that will need education as to what Winter Storm Uri is, what the Securitization Act does for them, and other questions. It is important that all of us work together as best we can to try to get education out to these consumers, that we do our best to try to alleviate any type of hardship that may occur. And we commend KGS for agreeing to try to work with us and others in terms of trying to get a low-income tariff or low-income assistance for those types of customers. We think that's important. And in addition to that, I have talked to Jim Zakura and I've talked to Terry Pemberton about this particular case to see what may be possible in terms of some type of public hearing in conjunction with the securitization proceeding that will be coming up. It's about that time that we will start to see bills come out to the various consumers for KGS. And it's important that they understand that will be 2 or 3 years after Winter Storm Uri occurred. People don't always remember why, but they'll see a $5 bill, a $5 increase on their bill, and they'll want to know why. So having some type of hearing where we can start to get that information out to the public is imperative. I think I've got the agreement of Terry and Jim Zakura that this is a beneficial thing, but we would have to work with the commission staff and with other parties to make sure that whatever we do put together is meaningful and does provide the information that we need to the public without really getting into a situation where we just say this is what's going to happen and allow parties to complain over it. So those are areas that we intend to work in terms of outreach. Certainly, we're going to use whatever mechanisms there are that we have to be able to get out to the public on this issue. And that brings us to the last question. Okay, so how does outreach, how will this affect our budget and our personnel? Well, as you know, the commission knows, CURB is a very small agency. We have 2 rate analysts. We have 2 attorneys. To be able to do the type of outreach program, which we should do, it takes personnel, it takes budget. And so we intend to ask for additional attorney, and we ask for an additional analyst to help us to be able to handle the different cases that we have. The truth of the matter is that if we lose one attorney, we become crippled. The learning curve for utility matters is quite high and quite complex. It takes a long time for an attorney or rate analyst to come to speed. So we need to have continuity. We need to have enough personnel that we can continue to do the work that we're doing. We would like to use the additional personnel to to consistently reach out and work with all stakeholders in the utility process, from the KCC staff to utilities to clean energy groups, et cetera. So that's what we see. I hope that answers the questions that the commission had for CURB. And I would be happy to answer any additional questions or clarify if I misspoke in any manner. Finally, if I could just close with regard to CURB's view on this settlement. Now, this settlement agreement, as the commission is aware, there are 5 factors that the commission weighs to determine whether or not it should approve a settlement agreement. And that is whether the parties have had an opportunity to be heard, whether there's substantial evidence that supports the settlement agreement, whether the settlement agreement conforms to law, whether the settlement agreement will result in just reasonable rates, and whether the settlement agreement is in the public interest. I don't intend to cover, but the most obvious of those, the first being whether or not the parties had an opportunity to be heard. If you look at the testimony of Janet Buchanan in this matter, there have been over 200 DRs that have been submitted between the parties and thousands of pages of documents in terms of discovery. There will be 2 hearings by the time this is over. There have been numerous settlement conferences and pre-hearing conferences and procedural conferences with regard to how this matter has proceeded. General Counsel Brian Fedotin needs to be commended. His ability to keep order in this proceeding, despite very many contentious issues and contentious parties, was superb. And as a result of that, this has been a meaningful procedure and a matter that is to be heard before the commission. We think all parties have had an opportunity to be heard. Clearly, this agreement conforms to Kansas law. The courts have spoken broadly and consistently that the commission has the authority to approve a non-unanimous settlement agreement if it finds that it is fair and just and reasonable and supported by the evidence upon proper hearing. That's why we're here. And so we believe that the commission will make that finding. Clearly, with regard to the commission, we have in compliance with KCC's rules and regulations, as well as the Kansas Administrative Procedure Act. And certainly the commission has authority to allow the recovery of prudent and reasonable cost. Finally, if I could talk about the public interest, and I'd like to echo the words that Jim Flaherty said eloquently. The cost of allowing some type of loss of life or loss of property due to the inability to keep the heat on during the worst winter that Kansas has suffered in decades is certainly within the public interest. To define the public interest in this docket, all the commission needs to do is to look at its own emergency order. In that emergency order, the commission required all jurisdictional utilities to do everything necessary to keep reliable service on throughout the entire winter storm Uri. Would the commission have had to issue the emergency order to require the utilities to do so? Absolutely not. That is clearly part of the regulatory covenant. It is written in Kansas law. Kansas utilities are absolutely required, no exceptions, to provide reliable and safe service to all of their customers. What the emergency order did was very important, however. The emergency order said that the commission stood behind the regulatory covenant, even in these bad times, even in the worst weather that Kansas has suffered in decades. It said that it required the utilities to continue to meet that regulatory covenant, to provide reliable and safe service during the entire winter storm Uri. And it also affirmed that it would live by its side of the regulatory covenant and allow the utilities to recover all prudent and reasonable costs associated therewith. That's the public interest. If we fail on any aspect of that regulatory covenant, then the whole regulatory scheme fails. The whole purpose for regulation fails. It's that deep. This issue is that centered in terms of what the public interest really is. Did KGS perform on its part? Absolutely. According to the testimony of Josh France in support of this settlement agreement, he states that 99.9% of all Kansas residents, KGS managed to keep the heat on. Should we keep our side of the regulatory covenant? Should residential consumers be required to pay the amount of reasonable and prudent cost? We believe so. We learned in kindergarten that we all are responsible for our own actions. Certainly where residential and small commercial ratepayers were concerned, we used the gas during Winter Storm Uri to keep our homes warm, to keep our businesses going, to keep our houses safe. It is only fair that we would be responsible for those costs. To echo Mr. Flaherty's questions, how much is it too much to pay to avoid what occurred in Texas? What would you pay to avoid losing one Kansas life? Certainly, I can't think of what that number would be, but I know it's certainly higher than $5 per month over the next 10 years. We believe that the settlement agreement is reasonable, and we would support the same. We hope that the commission will find that the settlement agreement is just and reasonable, fair, and supported by the evidence, and will approve the same. Thank you.
Thank you, Mr. Nicholl. Next, we have Mr. Schulte for Symmetry.
Thank you, Chairman French, and may it please the commission. Thank you for the opportunity to speak here today. As we discussed earlier, pursuant to the stipulation filed on December 15th, Symmetry and the other parties have agreed that Symmetry will file testimony on Monday, December 20th, and the stipulation reserves Symmetry's right to argue that the commission should consider that forthcoming testimony in this current financial plan proceeding. Accordingly, we urge the commission to consider the testimony that will be filed on Monday as they think about whether to allow KGS to charge customers the extraordinary amount of $366 million in extraordinary costs, plus an accumulated $15 million in carrying costs. That's at least $381 million, which is a huge number, with damaging economic impacts across the state, and it deserves careful scrutiny. First, a little background on who Symmetry is. Symmetry is a leading retail natural gas marketer that markets natural gas and serves as an agent to end-use customers in Kansas and across the region. Symmetry serves over 900 customers in Kansas. It provides gas to approximately 54 hospitals and healthcare facilities. It serves 46 separate school entities, including several school districts. It serves various government, county, and municipal customers in Kansas. I think we all can agree that Winter Storm Uri was an unprecedented event that threatened the health, safety, and welfare of Kansas residents. Facing the storm and recognizing the critical importance of maintaining energy services to the people of Kansas, the Commission issued an order on February 15th, directing utilities to ensure that natural gas and electric service continued without disruption, and allowing them to defer extraordinary costs into a regulatory asset account for subsequent Commission review. No one disputes these facts, and no one here would argue that ensuring people's lights were on and that their heat was working was the priority of everybody present here today. Speaking for Symmetry, its employees were working day and night to try to get gas to all of its customers. Many long days and nights were spent by Symmetry employees in their trucks and cars, charging their cell phones, trying to get work done when the power was out in their own homes and offices. It was a difficult time for everybody in this industry. But respectfully, what the Commission did not do in its February 15th emergency order was give utilities a blank check, and that is why we are here. This Commission is charged with looking both backward and forward, back to what could and should have happened in February 2021, based on what everybody knew at the time and what everyone could have anticipated. And the Commission must also look forward to consider what its decisions will mean for the future of Kansas customers in the natural gas market. Indeed, the Commission's emergency order and its order opening this specific investigation stated that the deferred costs associated with Winter Storm Uri, quote, shall be segregated by detailed cost category and shall shall be segregated in detailed cost category and shall contain enough detail for the commission to perform a subsequent review for prudence and reasonableness. Symmetry is not here demanding perfection, but we do ask this commission to give serious attention to whether KGS acted reasonably and prudently last February. We recognize that during the storm, everyone was working under unusual circumstances, but some of the costs that KGS asked this commission to approve and seeks to pass on to sales customers and marketers like Symmetry, indeed tens of millions of dollars, were simply not prudent or reasonable. Moreover, as you will see, the settlement, the financial plan settlement, has made no reduction to the gas cost component of KGS's total extraordinary costs since they filed their plan on July 30th. Additionally, the reduction in carrying costs is an illusory benefit. The 8.6% return was never just and reasonable. It does not reflect the actual cost of short-term debt used to purchase the gas at issue. And 8.6% would have allowed KGS to make a sizable profit on a natural disaster. The 2.0% is an improvement, but it still does not reflect the actual cost of debt. It is an artificially arrived upon settlement number that will still allow KGS to yield a profit from a natural disaster. Over the last couple of months, Symmetry has been working with KGS and staff to get access to data, and we have been working hard to analyze that information. Based on that recently available evidence, including information from KGS's own files, we question some of the decisions KGS made in purchasing costly spot gas, particularly on the highest price days. Now, based on pre-file testimony by other parties, we expect that you will hear that KGS's purchases and use of storage were generally in line with its gas supply plan, and that its purchases were made, quote, at market, end quote, prices. But that is it. The analysis in all cases effectively stops there and asks no more. Respectfully, this commission should decline to act as a rubber stamp. First, the gas supply plan does not establish a standard for prudence. It also contemplates average months, and February 2021 was anything but an average month. Acting consistently with a plan in place for normal months is not and should not be dispositive of prudence under these circumstances. Second, the parties maintain that because KGS paid at market prices for its spot gas, those purchases are necessarily prudent. As the commission will see, Symmetry's experts have examined KGS's gas purchases and considered factors including weather, demand, estimates of KGS's supply forecast, and storage balances. This information was all available to KGS at the time it made its decision. Our examination has assessed whether KGS actually needed to go to the market and purchase spot gas based on the information that would have been available to it at the time. And a point on the equities here. As acknowledged in pleadings and testimony from staff and KGS, penalties under tariffs serve to deter and provide consequences for bad behavior. As Symmetry's testimony will reflect, this is not a situation in which Symmetry acted in bad faith. Quite to the contrary. Symmetry lost tens of millions of dollars procuring gas for human needs customers. As the commission will hear, Symmetry is the asset manager for another utility in Kansas. During the storm, Symmetry's gas supply was directed to the human needs customers of that utility at a loss of tens of millions of dollars to Symmetry. Accordingly, penalties don't just prevent bad behavior, but the waiver of penalties can encourage good behavior. Symmetry prioritized human needs customers at a great loss to itself. If it is unreasonably penalized for its good faith actions, future suppliers in the same situation may think twice about acting in such good faith. In getting back to the particular costs proposed to be recovered by KGS, the commission should consider that KGS made a number of business decisions during the storm that, based on information known at the time, were imprudent and unreasonable and resulted in excess costs that should not be borne by ratepayers. With respect to carrying costs, a reduction from 8.6% to 2% is helpful, but Symmetry continues to believe that the carrying cost should reflect actual costs, not a number that provides any return to KGS as a result of this natural disaster. Additionally, legal and consulting fees are nearly $1 million based on recent estimates and are expected to climb higher. Typically, there would be a sharing mechanism for those expenses. The Commission is charged with protecting the customers of Kansas, and the issue of whether KGS prudently and reasonably purchased gas during the storm is obviously of great importance to Symmetry, to Kansas customers, and to the industry more broadly. Once the Commission hears this matter with the benefit of receiving all of the evidence, including evidence from Symmetry, we believe that it will show KGS has not met its burden to show that it and the proposed plan are reasonable, prudent, or in the best interest of Kansas customers. We know that the Commission will take that inquiry seriously, and we look forward to presenting you with our evidence. And lastly, in response to the arguments from Mr. Flaherty regarding Symmetry's rights to oppose and delay the financial plan, and his claim that Symmetry does not have the right to oppose and delay the financial plan. First of all, Symmetry is not proposing to delay the financial plan in any way. The order date of February 8th is still in place. We are simply asking the Commission to consider Symmetry's evidence when it issues that order on February 8th. If the Commission chooses, sua sponte, to delay the February 8th ruling by a few weeks, that is a small price to pay given the amount of the cost at issue and the importance of the issues to the future of the industry. Moreover, KGS has indicated that it will likely not be able to issue the bonds until 12 to 13 months from now. Accordingly, a couple of weeks delay, if any, in early 2022 will not have any material effect on when KGS issues its bonds. Accordingly, Symmetry is emphatically not asking the Commission to delay the financial plan or the issuance of the bonds. Secondly, to the point that Symmetry, to the claim that Symmetry does not have a right to oppose the financial plan, that just has no basis in fact or law. Everyone has agreed that the tariff penalties in this situation would be grossly unjust and unreasonable under the circumstances. And so therefore they should be replaced with an equitable allocation of actual costs. Both the financial plan proceeding and the waiver plan proceeding are about the same bucket of costs. There are only three categories of entities that can be assigned those costs. It's either KGS, the sales customers, or the marketers and individually balanced transportation customers. A decrease in one is an increase to the others and vice versa. Accordingly, there is absolutely no basis in law or fact to claim that Symmetry does not have an interest or a right to weigh in on the financial plan proceeding. With that, we thank you for the opportunity to be heard today, and we look forward to filing testimony on Monday, and we look forward to the Commission weighing and considering that evidence. Thank you.
Mr. Schulte. Finally, we have KCC staff, Ms. Pemberton.
Thank you, Commissioners. To the extent that my opening is duplicative, I'll apologize. There's been some good openings coming before me, so I'll try not to rehash old ground. So what I thought I would do is put into context what staff was really viewing at the time that Uri occurred and what we did with regard to our analysis of KGS's plan. So that's my perspective that I'll be presenting today. And for the purposes of the record, I am Terry Pemberton, appearing on behalf of the Commission staff. As the Commission is aware, in mid-February 2021, Winter Storm Uri imposed unusual and extreme freezing weather conditions across the United States. Winter Storm Uri prompted health and safety concerns, sudden and sustained natural gas supply disruptions, widespread infrastructure and operational failures, and freeze-offs of facilities that were necessary for the delivery of natural gas and electricity. We've all heard this similar recitation of fact, but such statements do little to put into context what we were really experiencing at that time. Some of the things that staff was dealing with leading into Winter Storm Uri began as early as Wednesday, February 9th, when we began receiving calls from at least one of our natural gas utilities that they were having operational concerns on their system leading into the event. On February 12th, which was the Friday leading into that 4-day holiday weekend, we received calls from non-jurisdictional utilities about the high price of natural gas for that weekend and their concerns about the potential lack of funds that they were going to have to cover their supply costs to ensure that gas continued to flow to their customers for even just for basic human needs purposes. Staff also received calls from large transportation customers that not only employ hundreds of employees across Kansas, but they're also involved in production in the food supply chain. Those entities were concerned about the potential penalties that would be imposed upon them in the event that they were unable to procure sufficient gas to cover their loads. Staff worked through that weekend. The Commission is well aware of this, attending numerous calls with utilities, attorneys representing various consumer interests, state and federal government leaders, all in the attempt to develop a plan to mitigate the devastating effect that the storm would have on the safety of Kansans. From these conversations, staff was also very aware and concerned about the financial impact that the storm was going to have on the Kansas economy. In response to what occurred over that weekend, the Commission acted swiftly on Monday the 15th, and it issued its emergency order in docket number 21, GIMX 303 MIS. That order acknowledged the state of disaster emergency proclamation issued by Governor Kelly at that time, the higher than normal wholesale natural gas prices that were being experienced, and the potential of reliability issues related to the prolonged winter weather. The emergency order required jurisdictional natural gas and electric utilities to do everything necessary to ensure that natural gas and electric services continue to be provided to Kansas consumers, and to take steps to mitigate the financial effects of a payment of costs associated with those actions. As we've heard from multiple parties so far, the Commission did authorize jurisdictional utilities to defer those extraordinary costs into a regulatory asset and carry those costs at the respective utilities' weighted average cost of capital. Such action is standard when the Commission has dealt with storms, major storms in the past. So this was not the weighted average cost of capital was not an extraordinary extraordinary thing that the Commission granted at that time. That was fairly standard for these unusual events. The authorization, so after the 21-303 docket was initiated, staff realized the practical difficulties that were going to ensue in trying to handle all of the investigations in one docket. For example, utilities maintain confidential information that shouldn't be shared among themselves. Gas and electric utilities also have separate and distinct confidentiality considerations and rules with respect to system operations. Those considerations would have been very difficult to maintain in one docket. And additionally, interveners that are interested in one utility, and we'll use KGS as an example, they would receive pleadings for all the utilities, despite the fact that their issue or interest may be limited to one utility. In recognizing those administrative difficulties, staff requested the Commission to open the company-specific dockets to look at the Winter Storm Uri events and how the utilities performed during those timeframes. The Commission granted our request or our recommendation on March 9th. I think it's important to note that nothing about staff's request to open the company-specific dockets had anything to do with creating silos under which the Commission would be unable to look holistically at this event. It was merely for administrative efficiencies, and staff has continued to look at this event holistically. The Commission's adoption of staff's recommendation, as I indicated, resulted in the opening of this docket, but it also resulted in the opening of company-specific dockets for Atmos, Black Hills, Pioneer, Evergy, Empire, and American Energy. Since the inception of that 21303 docket, staff has been conducting contemporaneous investigations on all weak jurisdictional utilities and has attended and participated in various seminars and presentations with respect to Winter Storm Uri. On May 28th, KGS filed a motion for limited waiver in this docket seeking commission authorization to deviate from section 11.06 of its general terms and conditions for gas service provisions in order to allow KGS to remove the multipliers from the calculation of penalties incurred by marketers and individually balanced transportation customers for violations of operational flow orders and/or period of curtailment orders issued by KGS during the winter event. Stated otherwise, the waiver would allow KGS to not impose multipliers of 2.5 to 10 times the Southern Star daily gas daily price for failure of those entities to deliver sufficient natural gas supplies during the event. On October 8th, a joint motion to approve a non-unanimous settlement agreement was filed in this docket relating to the motion for waiver, and the commission, as we've already heard, will conduct that hearing in January. In that portion of the proceeding, the commission will be determining whether to allow KGS to charge marketers and individually balanced transportation customers a price less than the stated tariff amount. From staff's perspective, that aspect of this proceeding is not relevant for the purposes of the cost to be charged KGS's sales customers, which is what we're discussing today. For purposes of what's relevant today, on July 30th, KGS submitted its plan to minimize the financial impacts of the winter event on its sales customers. Under its proposed plan, KGS would apply for a financing order in a separate proceeding pursuant to the applicable provisions contained in the Utility Financing and Securitization Act. The financing order would authorize KGS to issue securitized bonds to finance the extraordinary costs incurred as a result of the 2021 winter weather event. As staff witness Justin Grady will testify, staff conducted an extensive review of KGS's performance during the winter event and its incurred gas costs. During and after the event, staff was in constant communication with KGS with respect to system operations and supplies. As part of its investigation, staff propounded substantial amounts of discovery, participated in numerous technical conferences and meetings, conducted other communications with the various parties to this docket, and completed an in-depth analysis into both KGS's handling of Uri and its plan to reduce the financial impact of the storm on sales customers. Staff's analysis included a review of the purchased gas costs incurred by KGS during the storm under the Commission's prudency standard for gas purchase costs as established in its June 1, 2000 order in docket number 106-850-U. That docket is also referenced as 75-GIMC-009-GIG. Staff's analysis also reviewed KGS's performance in light of KGS's annually filed gas purchase hedging plan. The overall standard the Commission has provided to review the prudency and reasonableness of purchased gas costs is at market standard, as discussed in the 106-850 docket. KGS's purchases during Winter Storm Uri were consistent with, if not lower than, the prevailing market prices during the storm's duration. In fact, KGS paid a weighted average cost of $67.91 per MMBTU for purchased gas during February 9th through 12th. This was $36.87 per MMBTU lower than the average market price of $104.78 per MMBTU during the same time frame. Another point of comparison is looking at the market competitiveness of KGS purchases for the entire month of February. That analysis shows that KGS's total purchased gas cost for the month of February was $41.56 per MMBTU. This compares to the simple average of monthly index prices of $51.19 per MMBTU, which is calculated using the indices of the various pipelines from which KGS takes service. And I apologize, my voice is going clearly. Give me just a second. An important consideration with respect to staff's analysis is that staff did not conduct its analysis in a vacuum. Rather, our analysis of KGS's gas costs during the Winter Storm Uri was conducted against the backdrop of data accumulated over the preceding months relating to the experience of all jurisdictional utilities, as well as non-jurisdictional utilities. This accumulation of data allowed KGS to review, or allowed staff to review KGS's gas purchases comparatively with what other utilities and industry participants were experiencing during that same time. Staff also determined that KGS acted consistently with what's called for in KGS's gas purchase and hedging plan. That plan is filed annually with the staff. We have repeated meetings with the companies when they file those. And in fact, the company also meets with Curb as well when they file their plan. Mr. Grady went into great detail on how KGS fared and performed with respect to its plan, and I'm not going to rehash all that here. But based on staff's analysis, it's staff's position that this commission should consider that the gas purchase costs incurred by KGS during that time frame prudent and reasonable expenses that were required to continue providing a vital service during the winter weather event. After months of discussion and negotiation related to KGS's financial plan, the parties crafted the settlement proposal before you today for consideration today. As covered in more detail by KGS and Curb, the agreement provides that KGS's extraordinary costs of approximately $366 million incurred or prudently incurred, that KGS should be allowed to recover those costs from customers by seeking approval of a financing order pursuant to the Securitization Act. Of particular note, the agreement allows KGS to recover carrying charges of 2% on the outstanding balance of these extraordinary costs, which you've heard already is a reduction from the 8.6012% included in KGS's original plan. Thereby this reduces the carrying charges from approximately 70 million to approximately 15 million, which establishes the $55 million savings for customers. This 2%, I think it's important to point out, the 2% is well below what any private entity probably offered if they offered payment plans to their consumers or their gas customers. I imagine the 2% is well below what any private entity was offering. It's staff's position that the agreement represents a reasonable resolution of the issues in this portion of the docket. The agreement will result in just and reasonable rates. Ultimately, it's in the public interest and supported by substantial competent evidence in the record. And with that, staff recommends the commission approve the settlement agreement on the KGS financial plan as filed. Thank you.
All right, thank you, Mr. Pemberton. I believe I'm debating whether we give everybody a quick break, but I think we will launch into witnesses and then I will give you a break after Ms. Buchanan. So at this time, KGS, you may call your first witness. And before you do that, just a quick reminder, since we're over Zoom, for all the witnesses and counsel examining them, please speak slowly and clearly for the court reporter, because I know her job is made even more difficult over Zoom. So with that, Mr. Flaherty, please call your witness.
Yes, thank you, Your Honor. KGS would call Janet Buchanan.
Good morning, Ms. Buchanan. Can you hear me all right?
Yes.
Chair French, is it okay if I go ahead and place her under oath?
Yes, please.
Thank you. Ms. Buchanan, raise your right hand, please. You do solemnly swear the testimony you are about to give in the case now in hearing will be the truth, full truth, and nothing but the truth, so help you God.
I do.
Thank you.
State your name and business address for the record.
Janet Buchanan, Buchanan. My address is 7421 West 129th Street, Overland Park, Kansas, 66213.
Who is your employer?
Kansas Gas Service.
What is your position with Kansas Gas Service?
Director of Rates and Regulatory Reporting.
In that capacity, did you pre-file testimony in support of KGS's plan to minimize the financial impact of Storm Uri on KGS's customers?
Yes.
Do you have any changes or corrections to that pre-filed testimony?
No.
If I were to ask you the questions that appear in your pre-filed testimony, would your answers be the same today?
Yes.
Did you also pre-file testimony in support of the settlement on the financial plan?
Yes.
Do you have any changes or corrections to that pre-filed testimony?
No.
If I were to ask you the questions that appear in your pre-filed testimony in support of the settlement, would your answers be the same today?
Yes.
Your Honor, I would request that Ms. Buchanan's testimony in support of KGS's financial plan and her testimony in support of the settlement on the financial plan be referred into the record.
Any objection? Hearing no objections, the reference testimony exhibits will be admitted into the record.
And based upon the provisions contained in the stipulation, I would tender Ms. Buchanan for questions from Symmetry and the commissioners.
Thank you. Does Symmetry have any cross for Ms. Buchanan?
Subject to the stipulation previously referenced, we are reserving any cross of Ms. Buchanan.
Thank you, Mr. Schulte. We will move to commissioner questions, and I will begin with Commissioner Keene. If you have any questions for this witness.
Thank you, Mr. Chair. Just one question for you, Ms. Buchanan. First of all, thank you for being here this morning. I'm going to give you some latitude on this question. So if you could identify for us, in essence, why you believe that KGS has acted prudently and reasonably last February in purchasing gas and incurring the cost that you're now asking to be passed on to consumers.
Okay. Safety of our employees and our customers is the number one value for Kansas Gas Service. And so we believed it was prudent to do everything that we could to keep gas service during that critical time when lives could have been lost, substantial damages to businesses could have been incurred. And so we did everything we could to keep gas flowing during that time. We followed our gas supply plan, and we, as the staff has indicated in their testimony, our gas purchases during the storm met this commission's standard of review for such purchases.
Thank you. Thank you for your response. With regard to the last point that you raised, let me ask you to put maybe a little finer point on that for me, if you could. In terms of procuring its gas supply during the winter storm Uri, was it prudent for KGS to purchase some of its gas at spot market prices?
In order to maintain system integrity during that time, it was necessary for KGS to purchase gas on the spot market. Those purchases were made at the market standard, and I believe that staff and those who have signed on to the settlement agreement agree that those were prudent.
All right, thank you. One final question from me. In its opening statement, Mr. Schulte, on behalf of Symmetry, has alleged that the reduction in the carrying costs is an illusory benefit. I think I'm paraphrasing him correctly there. And his, I think, rationale in essence was the carrying cost should reflect actual costs. Can I have you respond to those positions?
Sure. The commission's order, emergency order, indicated that utilities could defer those costs and include carrying costs equal to their weighted average cost of capital, which was the normal practice for regulatory assets related to emergency events. The reduction to 2% was part of an overall settlement agreement, and it also allowed KGS to gain some additional signatories to the penalty settlement agreement. And it recognizes, from at least KGS's perspective, that we have a variable rate for at least part of the term loans that are associated with the debt we incurred to finance those gas costs. And so there's still potential for that rate to fluctuate upward before we are able to issue bonds if the commission approves this financial plan and issues a financing order.
All right, thank you for your answer. I appreciate your testimony very much. Mr. Chair, that concludes my questions of this witness.
Commissioner Keen. Commissioner Duffy, do you have any questions for this witness?
Yes, I do. Thank you. Good morning, Ms. Buchanan. And I'm going to follow on with Commissioner Keen. So what you're saying is that while the settlement proposes a 2% carrying charge, because of market variations and the economy as a whole, that between the time of the settlement and that that's actually realized, it may not be 2%. Is that correct?
The carrying charge will remain at 2%. The debt costs that KGS is incurring, there's the potential for that rate to fluctuate.
Okay, very good. Do you believe your company did follow its gas supply plan as it was shared earlier in the year? Well, I guess the previous year with the commission?
Yes, I think the evidence in the record shows that KGS did follow its gas supply plan. We had gas in storage, we had base load, and then during the storm, when it became difficult to maintain system integrity, and to address the additional demand from customers, we had to purchase additional gas.
So in terms of your storage, was that storage amount depleted drastically during the few days of Storm Uri?
According to testimony provided by, Mr. Robbins, there were days that when we looked at the forecast, we would have been down to only 2 or 3 days of storage for the remainder of the month. And then, as you know, March can also be cold in Kansas. And so we would have been, putting ourselves at risk for having enough storage later into the shoulder months of the year.
So I guess what I'm hearing is you didn't deplete it down to 0 to get you through the crisis, but instead, as I believe it was Mr. Schulte said, you purchased costly spot gas on the highest day at market price.
That's right. There are also limits to the amount of gas that a utility such as KGS can withdraw on a particular day. There are maximum daily quantities. And so we had to balance that as well as managing the amount of supply we would have available the rest of the winter.
Okay. Thank you. Let's go back before the storm. So there were predictions a week out that it was going to be extremely cold. And as we got closer to the weekend, those predictions became more firm. And I think we all saw the drastic nature of what was going to happen. Do you believe your company took advantage of that time to prepare for the storm? And what exactly did they do?
I believe our company did take advantage of that time appropriately. As I said in response to Commissioner Keen, safety of our employees and customers is paramount. And so we began having meetings early prior to the storm to make sure we were going to have personnel stationed appropriately throughout the territory so that They could easily get to the facilities they needed to be able to monitor to make sure that we could maintain service. We made sure they had the equipment they needed to be safe in the elements that they would be facing. We set up communication lines so that we'd be able to reach each other quickly and with confidence that we could do that in all situations. And gas supply began looking very closely at the forecasts and the data and looking for where they would be able to find supply if they needed it.
Did you believe your suppliers were aptly responding to communications to your company?
Mr. Robbins would probably be able to fill us in more more completely, and I can check with him. But I believe from my discussions with him that they felt they were getting adequate, adequate communication from suppliers. Not always news that we wanted to hear, but we were being informed so that we knew what we could plan on as far as supply.
Okay. Can you visit briefly about the proposed tariff for low-income customers? You have about a year to file something with the commission. What are you looking at here? What do you consider in that proposal?
Well, Oklahoma Natural Gas, our sister company in Oklahoma, has a low-income tariff that I think we will first bring to CURB and to staff to review with us and see if that is something we can make work in Kansas. It is a tariff that provides for a lower rate. Both the customer charge and the volumetric charges are lower for people who meet the federal guidelines for income to qualify for LIHEAP. And so that would be, I think, a good starting point, but we are certainly open to more dialogue with staff and CURB on how to move forward with that. And that's part of the reason for allowing some time to get that put forward, but we would make every effort to do that as prior to the next winter.
Okay, so this would be ongoing, not just during a limited time, but kind of a new, well, it would be a new tariff added.
Correct. It would be in place ongoing.
Okay, very good. Let me look here. I believe that does complete my questions. Thank you, Ms. Buchanan.
Thank you.
Right. Good morning, Ms. Buchanan. I have just a few questions. I want to make sure I'm thinking about the financial aspects of the settlement in the right context. So I'm looking at nothing specific, but I'm looking at the total number of extraordinary costs of $366 million that have been identified. Can you confirm for me that that amount includes all the amounts that were necessary to keep the system balanced, including amounts that may have been demanded by non-sales customers?
That's correct.
Okay. So even though some of that gas may have been used by others, it would be KGS's position and the position of the settlement that this amount was necessary to ensure system integrity for all gas sales customers, correct?
That's correct.
And so it would be the position that even if no amounts were recovered through penalties, that this full amount would be just and reasonable to be recovered from just sales customers, correct?
Correct, because to maintain system integrity, all customers benefit from that maintenance of integrity. No service was lost no property damages were incurred, no lives were lost because of a lack of gas service. So there ultimately was a benefit to everyone for KGS maintaining service.
Thank you. That is what I needed. I just wanted to be crystal clear on what we are saying in this settlement. If we look at that 366 million, well, I guess one final question on that, and that is because that includes amounts of gas that were used by non-sales customers. That is why, if there is extraneous to this, a recovery of penalties from non-sales customers, that amount will be reduced in the future, correct?
Correct. If the penalty amounts are collected prior to the time we issue, and assuming that this settlement is approved and a financing order is approved, if those penalties are collected prior to the issuing of securitized bonds, then the penalties will reduce the amount that needs to be securitized. If the penalties are collected after that time, then we can flow those benefits back through the cost of gas rider and the ACA mechanism that's associated with it.
Thank you. All right. Now I think I'm getting close to the end. I don't have much here, but just a couple more details on the financial aspects. That 366 million, I'm looking at the chart on page 11 of your testimony in support of the settlement. And in this chart, I think you're just breaking down at an extremely high level the $366 million of extraordinary costs. I see that you have $6 to $7 million of financing fees.
Yes.
But I'm understanding that's not the $15 million of carrying costs. The $15 million of carrying costs are in addition to the 366 million. So the total amount to be financed when you eventually issue the securitization bonds, assuming there is nothing recovered through penalties, would be more like $381 million.
That's correct.
Okay. And the 2% carrying cost agreement, that 2% assumption of carrying costs, that only applies for the period between the winter weather event and the date of the issuance of the securitization bonds, correct? So that's maybe a two-year period?
That's correct.
Okay. That does not include carrying costs over the life of the securitization bonds at whatever interest rate they come out at.
Right. Well, once we move to that next phase of these proceedings, assuming we move forward, then we'll work to structure a financing order that would allow us to get the highest rating that we can for bonds, which would in turn get us the lowest rate possible, and most likely below that 2%.
I know we have some estimates of monthly bill impacts once that occurs. You don't necessarily have to go into detail of what the assumption is, but I assume those include an assumption of what you think the securitization interest rate would be.
Yeah, the analysis that was provided in my direct testimony included a 2% rate, but that was a fairly conservative look. I think especially for the longer term bonds, we may be able to get something lower than that.
Okay. The only other question I had was on the that 2% carrying charge over these, perhaps 2 years that's going to occur between the event and when the securitization bonds are issued. I believe in Mr. Gorman's testimony in support of the settlement, he identifies that 2% is actually slightly higher than what KGS's actual carrying costs will be over that time. I think he estimates it around 1.5% based on a data request that you responded to. Mr. Gorman says that this is reasonable because this is a small allowance for any increase in the floating interest rate, because I think he's recognizing that 1.5% is floating. Could you give me any additional color on how likely it is that KGS would be exposed to a risk of a change in interest rate over the next few months to help me understand why it's reasonable to add that extra 0.5% allowance, I suppose?
Sure. The portion of those of our term loans that's subject to a variable rate, that rate varies, I believe, on a quarterly basis. And so given the current financial climate where we're expecting, or many people are expecting inflation to occur, there's that risk involved over the next year before securitization would happen.
Okay, so you basically have that risk. I think somebody mentioned it would be 12 to 13 months before the securitization bonds would be issued. So that risk exists during that full time period.
That's correct.
Okay. I think that is the conclusion of all my questions. Thank you. Commissioner Duffy, do you have a further question?
If I could, and let me ask you, Ms. Buchanan, did KGS's bond rating, did it decrease after the storm?
Yes.
Okay, what was it prior to the storm and where is it right now?
Prior to the storm, S&P had a rating of A2 and stable, and Moody's had one gas. That was Moody's A2 and stable, and A and stable from S&P. And then after the storm, S&P downgraded one gas 2 notches to BBB plus negative watch, or negative outlook, and Moody's downgraded by 1 notch to A1 negative outlook.
Is that where you are today?
Yes.
So why is that significant? 1, and 2, does that, will that, with an issuance of an order, let's say the commission approves the settlement agreement, will your rating automatically go back up? Or tell me how that's going to work, perhaps.
The significance of the downgrading is that affects the cost of debt, any future cost of debt that one gas incurs or KGS incurs. And so that for any future borrowing, we would need to meet our capital needs. That would increase the cost that ultimately our customers would pay. And so that's the down or the negative impact of having been downgraded because of the storm. I think it will take time to recover that rating, but certainly if we're able to issue securitized utility bonds that we are seen as less risky, and we've taken care of that debt in a way that would satisfy the rating agencies that we can manage that debt.
Okay, real quick, we're talking about Kansas Gas here, but you mentioned one gas. So are we talking about the rating on one gas or Kansas Gas?
All of our borrowing is done at the one gas level. And so the rating agency for the overall the rating for the overall company is also what's applied to KGS.
Okay, all right, thank you. Thank you, Chair French.
You. I think I'm gonna go to Mr. Flaherty first for redirect, unless, I know Mr. Schulte had requested the ability to do cross based on anything that came up in commissioner questions. Mr. Schulte, do you intend to have any cross?
No, we will, not at this time.
Okay, then we will move to Mr. Flaherty for redirect.
Yeah, no redirect, Your Honor. Thank you.
Very good. All right, let me pull up my list here. I think I am going to give everyone a short break before we move to the next witness. So we are now in recess and off the record. We will take a 5-minute break and return at 10:45 our time.
Yeah, we're muted. We can test it and get back online. Is it, you're not just.
Some folks are still, their volume is still on, guys, just so you know, they're not all phones are muted.
Yeah, Chair French, just a quick sound check, if you don't mind. This is Justin Grady.
You sound great.
Okay, thanks.
Before we go back on the record, I see David Nicholl there. David, I just want you to know how much I had to bite my tongue with you commending Brian Fedotin in your opening statement. I mean, I wanted to chastise you, but
Actually, Brian did an amazing job. This.
I don't want to hear it.
Oh, okay, I apologize. I will watch what I say in the future, but I will think nonetheless how.
I will grant administrative notice of your comments.
It's in the transcript now, I'm pretty sure. All right. It looks like I see Commissioner Duffy. I do not see Commissioner Keene yet. We will wait for Commissioner Keene to come back on screen before we do move back into the record. Okay, I see Commissioner Keene. Commissioners, can both of you give me a thumbs up if you are ready to go? All right, very good. Okay, we are back on the record and reconvened for this evidentiary hearing. At this time, we will resume the examination of witnesses. And Mr. David Nicholl, you may call your witness.
Thank you, Chair. CURB has one witness, Josh France.
If I need to speak to get registered.
Mr. France, can you hear me all right?
I can, thank you.
All right. Is it all right if I go ahead and place the witness under oath? Thank you. Sir,
Yes.
Raise your right hand, please. You do solemnly swear the testimony you are about to give in the case now in hearing will be the truth, full truth, and nothing but the truth, so help you God.
I do, yes.
Thank you.
Thank you. Before I begin, I'd like to thank the court reporter for her work in this proceeding. So with that, would you please state your name and spell it for the record?
Yes, my name is Joshua P. France, and my last name is spelled Frantz. I go by.
Thank you. Thank you. By who would you state your employer and your business address for the record?
Yes, my employer is the Citizens Utility Ratepayer Board, CURB. My business address when I'm not working from home is 1500 Southwest Arrowhead Road, Topeka, Kansas, 66604.
What is your capacity of the job description? What is your job description with CURB?
Yeah, I am a senior regulatory analyst.
And in connection with that job, did you cause to be pre-filed in this docket, pre-filed testimony in support of the settlement agreement consisting of 17 pages?
That's correct.
Do you have any corrections to that testimony today?
I do not.
Now that you're under oath, Mr. France, if I were to ask you today the questions that are contained in your testimony, would your answers be those that are contained in your pre-filed testimony?
Yes, they would.
May it please the commission, I would request that the commission spread upon the record the pre-filed testimony of Josh France in support of the settlement agreement.
Is there any objection? Hearing none, the reference testimony will be admitted.
Thank you. And with that, I would tender Mr. France for questions from Cemetery.
Mr. Nicholl, your audio is breaking up. If you could just say that last sentence over again for the court reporter.
Thank you. Sorry. I would request that the testimony of Josh France, consisting of 17 pages in support of the settlement agreement, be spread upon the record.
I think we did get that, and it is admitted into the record. And then I believe you were tendering the witness for cross. Is that correct?
I apologize. Yes, I would tender the witness for cross-examination from Symmetry and for any commissioner questions.
Very good. Thank you. Does Symmetry have any questions for this witness?
Thank you. Subject to the previously noted stipulation, we are reserving cross-examination.
All right, we will move on to commissioner questions. And again, I will begin with Commissioner Keen. Do you have any questions for this witness?
Thank you, Mr. Chair. I have no questions for this witness. Thank you.
Commissioner Duffy, do you have any questions for this witness?
Yes, I do. Good morning, Mr. France.
Good morning again.
So in the opening statements, Mr. Nicholl did talk about the outreach that's going to be necessary for customers to understand Storm Uri's increase. So I have a question. Will this be a separate line item on the KGS bill that a customer would receive?
Yes, and I think possibly in the settlement agreement somewhere it actually spells out the precise language that will go on the bill, but I think it's something along the lines of, you know, Winter Storm Uri recovery surcharge or something like that. But it's formalized, you know, that it'll be a line item and it'll have a name.
Okay, so the amount that we're talking about for a residential customer, assuming that a securitization is accomplished, the amount that will be on the monthly bill, the estimate is how much?
Well, that's hard to say. There's a lot of factors. It depends on, and that's part of why we're reserving this aspect to the financial order. So, you know, if you look at KGS's proposal, they have, I think they have a 5, a 7, and a 10-year securitization options. On top of that, I don't think there's anything in the record that reflects the decrease of the carrying charges. So I think, as Mr. Flaherty mentioned, I think that will change those amounts by maybe $1. But that's, I don't know that that's been formalized. You know, CURB potentially has some concern as to whether the charge should be fixed or variable. If it's variable, you would certainly have an average bill impact, but you would not have a concrete known bill impact. If it's fixed, then you would know the exact bill impact per customer, probably subject to some sort of true up each year. But yeah, so there's a lot of factors at play. I believe, like, if you went with the 10-year, I believe it would be about $5. But again, I'm not sure if that's inclusive of the 2% carrying charge. And as Ms. Buchanan discussed, you know, when you get to the financial process for the securitization bonds, we don't know for sure what those rates are going to be. As she stated, she said she used 2% and that was being conservative. But I think that was all put together 6 months ago. So, you know, there could be some changes there. But I wouldn't expect it to be, you know, I mean, the whole point of securitization is to get a low interest rate. So I wouldn't expect it to be extreme.
Okay, so let's just go with the 10-year of about $5. So for 10 years, approximately $5 would show up on the bill every month to pay for the residential usage. So comparatively, during a rate case, how does this $5 look? Is it, with your experience, is it more than what normally occurs in a rate case, where the company comes in, asks for additional costs, and there's a hearing and the commission makes a decision? So how does this Storm Uri amount tally up to potential rate case amount?
I hate to deflect here, but CURB typically hires a consultant when it works with rate cases, and I don't want to speak incorrectly, and I don't want to put Mr. Grady on the spot, but I know he's going to testify after I do, and perhaps he could better answer that question. I know he has a lot more experience than I do as far as a tenure.
That's fair. That's fair. Okay, I'll save that question for him. So let me ask you, you're going to, over the next year, help to develop the outreach program to make sure folks understand why this additional charge is showing up, as Mr. Nicholl alluded?
Yeah, that would be our goal. And certainly, as he discussed, we're looking at the possibility of public hearings. CURB's always involved in those public hearings, as you know, with any sort of rate case or really any sort of public hearing. CURB's always involved in those.
Will you also be involved in the determination over the next year by KGS of what a low income tariff for KGS customers would look like?
Absolutely. And not to get into the details of settlement conversations, but that's something that CURB has wanted for a long time, and that was that was pushed by CURB for settlement, that low income tariff option. I realize that in the settlement it's fairly vague. It just says KGS will propose something within the next year or so. There's a lot of moving pieces with this. CURB and staff have had discussions about this, and I know there's some concern about basically rate discrimination and discriminatory pricing, and whether or not you can give a discount to low income customers. So one of the things that CURB is looking to, because certainly before the company would propose a tariff for low income customers, there will be one legislative session. So, I think we're looking to at least broach that subject legislatively. And if there's some sort of bill that would, be possible that says, that defines a low income bill or some sort of low income discount as acceptable, that would certainly be helpful. And it would open up some more avenues and possibly make approval of such a tariff an easier process. But that's there's a lot of things that could happen in the next year, but that's certainly one of the things that we're looking to is legislation.
Okay, but not necessarily that you would introduce it as CURB?
That I don't know. I mean, that would be a better question for Mr. Nicholl. Yeah, I'm sure you could. There's going to be another hearing, obviously. So as we did this time, anything that you ask me that I'm not able to answer at the time, I'm sure he can work into his opening statements later.
Okay, fair enough. If I could ask you, if I was a new customer coming in from out of state and moving into KGS territory, will I see this line item on my bill?
Yes, you will. And that's one of the concerns is the intergenerational inequity. But that is an issue for almost everything the utility does. If you spread costs over a long period of time, you're going to have some customers that pay for something that, was not used by them per se. And I will say, one of the customer contacts that we had was, I believe it was a customer that was a non-jurisdiction utility who had already paid his bill up front in a one-time, there was no payment arrangement. So I believe he had paid his non-jurisdictional utilities winter storm charge already, and was concerned that, he was going to move, and he was concerned that whatever utility he was going to, he was going to have to pay again. And so I'm sure you've seen in these settlement agreements, there are some stipulations that sort of protect against those rare circumstances. And they're pretty limited, but that's something that we sort of brought to the attention and was discussed in the settlement process as far as, is there something we can do for those customers who have, paid in full already a cost from a different utility that are coming in. And again, it's pretty limited, and I don't know how often that'll happen, but that is certainly, as you mentioned, the intergenerational inequities are a concern. But we still think this is a fair settlement.
Okay, all right. Those are all the questions I have. Thank you, Mr. Franz.
Yeah, thank you.
Mr. Franz, I don't believe I have any questions for you. I think I got everything answered by Ms. Buchanan, and then I do have a couple questions for Mr. Grady, but I think they're probably best reserved for him. So I don't think I have anything further for you. Let me ask at this time, Mr. Nicholl, do you have any redirect for your witness?
No redirect.
All right, very good. I believe you may step down out off the virtual witness stand, Mr. Franz.
Thank you.
At this time, staff, you may call your witness.
Thank you, Chair. At this time, staff will call Justin Grady.
Good morning.
Good morning, Mr. Grady. Can you hear me okay?
Yes, ma'am, I can.
Is it all right if I go ahead and place the witness under oath? Great. Sir, raise your right hand. You do solemnly swear the testimony you are about to give in the case now in hearing will be the truth, whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
All right, Mr. Grady, will you please state your full name for the record?
My name is Justin T. Grady.
And by whom and in what capacity are you employed?
I'm employed by the Kansas Corporation Commission, and I am the Chief of Revenue Requirements, Cost of Service, and Finance.
And what's your business address at the commission?
Business address is 1500 Southwest Arrowhead Road, Topeka, Kansas, 66604.
Thank you. Are you the same Justin Grady that caused to be filed in this docket on November 30th? The direct testimony and testimony in support of a settlement agreement consisting of 63 pages, including attachments?
I am.
Was that testimony created by you or at your direction?
It was created by me.
Okay. Do you have any corrections to make to that testimony at this time?
Not that I'm aware.
Okay. If I asked you those same questions today, would your answers be the same?
They would.
At this time, I would move the testimony and attachments of Mr. Grady's testimony to be entered into the record.
Are there any objections? Hearing none, the reference testimony exhibits will be admitted into the record.
Thank you. And I tender Mr. Grady for commissioner questions.
I actually have symmetry listed here as cross, but I assume Mr. Schulte, you take the same posture with this witness as the previous?
Yes, thank you. Pursuant to the stipulation, we'll reserve cross.
Okay. Then we will move to commissioner questions, and I will begin again with Commissioner Keene.
Thank you, Chair French. Good morning, Mr. Grady.
Good morning, Commissioner.
Justin, if with the indulgence of all of those who have read through the record, you and my fellow commissioners, I want to briefly see if I can review for those who may be listening in, members of the public who aren't easily privy to the documentation in this record, see if I can summarize what I believe are your conclusions. And let me do that very briefly and then have you either concur or non-concur in that. As I understand it, the staff here is contending that the financial plan is reasonable, the KGS financial plan is reasonable, and that it is a balanced plan that minimizes the financial effects to sales customers of these extraordinary costs that were incurred incidental to Winter Storm Uri, while allowing KGS to maintain financial integrity and recover necessary carrying costs. I believe you've also concluded that the plan presented by KGS will, if approved, allow sales customers to pay for extraordinary costs associated with Uri over an extended time period and would roughly increase typical customer bills by between $5.07 and $9.30 a month, depending upon the maturity of the securitized bonds. I believe that you have also acknowledged that while these charges are certain to be a hardship for many KGS customers is less of a hardship than it would be to pay these costs over a one-year period beginning in July of 2021. A result that I think most would agree would be untenable. As I understand it, you are concluding that while the original plan filed by KGS in this docket was in compliance with the Commission's emergency order, in that it included carrying charges at the KGS weighted average cost of capital. The plan was modified as a result of the agreement. And as a result, we have a reduction in carrying costs of roughly $55 million from originally what was anticipated at a little over 70 million to roughly 15 million. As I understand it, the staff's review indicates that the KGS gas purchases during the February 2021 Winter Storm Uri timeframe were consistent with the gas purchase and hedging plan that the utility files on an annual basis. Mr. Grady, have I accurately portrayed the essence of your conclusions in this docket?
Yes. Yep. Commissioner, you have.
Justin, let me ask you for the benefit of the record, and I think for the benefit of myself and certainly my colleagues, essentially the same questions that I asked of Ms. Buchanan. I start by asking you this, in terms of in the gas supply plan to start with. In terms of procuring its gas supply during Winter Storm Uri, was it prudent under the circumstances for KGS to purchase some gas at spot market prices?
Yes, I certainly believe that it was. I went through KGS's spot market purchases and the percentage of their total gas purchases that those spot purchases represented in my testimony. And, a lot of the specific details and the actual volumes of gas purchased and over what period of time, a lot of that is confidential because it's market sensitive data. But, one factor that I recall specifically from that testimony that's not confidential is the fact that around 32% of the gas molecules that KGS purchased during this event were subject to the extraordinary daily gas market fluctuations that we experienced during this period of time, right? And so, that's when you hear that, and then you think about the magnitude of the costs that we are discussing in this proceeding, that's in my mind, every time I think through those numbers or I hear that statistic, that's pretty staggering, right? I mean, only 32% of the gas they purchased during this period of time was priced at the daily gas price indexes. And yet still, here we are, right? $360 million worth of gas purchases. And so, KGS's spot market purchases were less than 10% of the total purchases. They don't frequently rely on the spot market to serve their natural gas customers. It was obviously a result of an extreme demand on the system. It was obviously a result of the fact that, the purchases that the demand that customers were making on the system during this period of time were right at twice the normal level of expected consumption that came out of the gas purchase plan, right? 1.92 or 1.91 times normal expected consumption. And so, I went through it in some detail in my testimony, but, a gas utility plans their system, they buy baseload gas, at stable prices. They do their best to hedge that gas. They utilize storage, and all of that is called for in their gas purchase and hedging plans. And then when all of those resources have been exhausted, the gas utility's only option really is to access the daily physical gas market, right? And that occurred in this case through either spot purchases or prearranged sort of peaking contracts that the company had access to, which were basically at daily physical gas index gas market prices plus a predefined adder. And all of those contracts were executed through a competitive bidding RFP process. And those are the resources that the company had at its disposal. And if they did not utilize the daily physical gas market to fill that gap, then I absolutely concur with some of the statements that are earlier in the record that, the result of that would have been catastrophic. I mean, if the gas utility had not taken the steps that it did to purchase those additional gas supplies over and above everything it had already secured and lined up for the storm, then the result very well would have, I was going to say could have been, but the result would have been, serious loss of service, of natural gas service during extremely cold and adverse winter weather conditions, which would have resulted in, significant property damage, loss of life, et cetera. So yeah, I absolutely think that the company did what was necessary during that period of time and prudent as well.
Very well. Thank you for the granularity of that answer, which pretty much covered a lot of territory in my second question. But beyond some of these cost factors, I'm going to ask this second question, and not to be repetitive, but to the extent you wish to embellish it with the parts of this next question that you haven't answered already. I think you've approached the question of prudence and reasonableness, but let me ask you this. Did KGS act prudently and reasonably last February? You've addressed the purchasing gas part of it. I would also ask in incurring the costs that they're now asking to be passed on to consumers. And if you could, in that respect, in essence, identify to us what are the most significant, salient, or consequential reasons for that conclusion if you believe they have acted prudently and reasonably.
So I guess in my mind, the most salient point regarding that KGS's actions were prudent during the event is it, and the specifics of which I went through in my direct testimony, but I mainly compared KGS's actions leading up to and during the event against their filed gas purchase plans, right? And to a lesser extent, because I have experience reviewing the actions and the decisions and the plans of other jurisdictional gas utilities in the state, jurisdictional electric utilities, non-jurisdictional utilities in the state. We're in the fortunate position, I guess, as a party in this proceeding that has access to a lot of confidential information from a lot of different parties, and even information that those individual parties don't have access to from the other utilities, right? So, I know what Black Hills did during the storm, but KGS doesn't know precisely what Black Hills did. All right, and KGS doesn't know Black Hill's plan. So we know what Atmos did and how they prepared and what their plan said, but KGS or Black Hills don't know those precise details. So, you know, I'd say that that helps and that gives us you know, an advantage certainly when we're reviewing the prudence of these companies' decisions, but some of those nuances and some of that detail doesn't come through in the direct testimony, right? But from KGS's perspective, I mean, what I focused on is, and this is just the way that these gas purchasing decisions are made, right? A gas utility, all it can really do is as far in advance as possible, try to predict what how much gas it's going to need during normal weather for, you know, look with sophisticated statistical methodologies and 30-year weather normalized usage patterns and you know, computer learning and automated advanced intelligence computer software. They try to predict how much gas people are going to use during normal weather and during extreme weather scenarios. And then they basically make their gas purchases and their gas purchase planning decisions based on normal expected weather. And they have a plan every month of the year that says, this is how much gas I need to purchase under normal weather. And here's what would happen if weather got extreme and how I would purchase that gas. And this is how much gas I need to have in storage at the beginning of the month. Here's how much I plan on taking out during a normal month. Here's how much I plan on taking out during a peak day event. And here's how much storage, how much gas I need to have in storage at the end of the month. Right. And I went through a lot of those details in my testimony, which, you know, I know that the specific numbers and the MMBTU quantities and the percentage of some of those decisions is confidential, but hopefully for, you know, members of the public or the legislature or others that are watching, you know, the conclusions and the depth and the data, the analysis that's there, hopefully that comes through. But I mean, KGS acted consistent with the plan that they file and that we review every year. They had sufficient gas in storage going into the storm and going into the month of February. They had more gas in storage going into the month of February than their plan called for. And then during the storm, they took so much gas out of storage that at one point during the winter event, they were down to 3 days gas storage on some of their biggest gas storage fields and their most important pipelines to the company. And so, you know, obviously if you get to a place like that and you're only halfway through winter, then it's time to back off and you know, you can't use as much storage. And so that's what the company did. And you know, that's all sort of described in painful detail in the discovery responses in this case and summarized at a certain level in the direct testimony. But by the end of the month, the company had refilled its storage back up to where, you know, they were where the plan called for them to be again, going into the month of March. And I think just one last little sort of subjective thing that's not so quantitative or based on just the numbers, and that's that you know, when we do these reviews and when we're trying to determine whether the company acted prudently, I really strive with everything I have to say, what did I know at the time? What were the, you know, what would a reasonable person in the industry have known? You know, in other words, I try not to complete this review with the aid of hindsight or hindsight, you know, prudence review. It's because going into the month of March, we didn't know if we were going to have another event, another winter storm Uri event, right? So it needs to not be completed with the aid of hindsight. It needs to be at that moment, what would a reasonable person in the industry, how would they have made their decision? and what was reasonable and prudent and cautious and appropriate at that time. And that's how we generally try to view these decisions. And that's the lens through which I viewed it. And as a result, I think that KGS's actions were prudent.
Thank you for that very detailed and helpful, your insights and your overview. One last question for you, Justin, if I might. In his opening statement, Mr. Schulte, on behalf of Symmetry, alleged that the reduction in the carrying costs is an illusory benefit. And I'm trying to accurately paraphrase him, that the carrying costs should reflect actual costs. Your take on that allegation?
So yeah, unsurprisingly, I disagree with Mr. Schulte's assertions in this regard. So a couple of things. I mean, the commission's emergency order did allow for the accumulation of carrying charges at the weighted average cost of capital during this event, right? Sorry, it did allow for the accumulation of carrying charges at the weighted average cost of capital for costs that were incurred during this event. And I think it was Ms. Buchanan that said that's essentially in line with or consistent with commission precedent. And that's absolutely accurate, right? I mean, if you go back and look at an ice storm or devastating, tornado or some sort of extraordinary, unusual cost that's outside of the control of the utility and that potentially will implicate the treasury functions of the utility. In other words, the utility's got to use its capital in some form or fashion in order to cover these charges. The commission allows accumulation of and typically recovery of weighted average cost of capital. So, I mean, you go back and, I mean, I understand, the arguments. There are arguments on all sides of the spectrum with regard to this particular issue, but it's not, necessarily easily derived, yes or no type of an answer. But the assertions were that, the company's trying to profit from a natural disaster and look, I know sometimes the word profit is used as a dirty word, but the reality is that profit is cushion. It's cushion over and above actual debt costs, in part because that's the reality of the world, right? In other words, if you look at the debt rating agencies or you look at the materials that are published by credit rating analysts or debt rating analysts, they require one gas and KGS to have a cushion over and above their actual cost of debt, right? These are private for-profit entities that have to raise their financing costs from the financial markets, right? They don't get this money from the federal government or somebody that has to give it to them. So they have a debt rating and they go to the public debt markets and they raise these costs. And the men and women and investment managers and other people that are giving these utilities this money, these borrowings, they require a certain level of assurance, a certain cushion, a certain profit margin. And so there are ratios, right? Funds from operations to debt and other credit metrics that have to be maintained. And the only way you maintain those ratios is by having either an equity return or a slight margin or a slight cushion over what your actual debt costs are, right? And so if, as utility regulators, if we allowed a utility, even a not-for-profit utility, to only recover precisely the dollar amount of debt costs that was on the debenture or the publicly traded, debt instrument, then they would never be able to borrow the money in the first place, right? I mean, later today, I'm going to file a report and recommendation on Southern Pioneer Electric Company Winter Storm Uri expenses, right? They're a not-for-profit utility that is owned by a consumer-owned cooperative. They have carrying charges and a cushion over and above their actual debt costs. They're not-for-profit utility. Why is that? It's because they have lenders that require those kind of cushions, right? So I'm sorry I went into that level of detail there, but the assertion that we should track the actual dollar amount of interest expense and only allow the company to recover that amount is it's just not reality. It's just not rate making. It's not reality. And you know, the 2% is it was a negotiated figure, certainly, but it was heavily dependent upon and derived from their actual debt costs. It is an accurate statement to say that a portion of those debt costs are variable. And so we don't know, we can't predict the future. We don't know how quickly interest rates will rise or if they will at all. But it was in recognition of the fact that a portion of those costs are variable, but it's also in recognition of the fact that utilities aren't just debt collection mechanisms. The reality of it is there has to be a cushion. There has to be credit metrics that can be maintained. And that's where, you know, that's how you arrive basically at the 2%. But I certainly disagree wholeheartedly that it's an illusory benefit. I mean, I would argue that commission precedent and commission practice is to typically allow weighted average cost of capital for extraordinary expenses like that. And so I'm certainly glad and appreciative of the fact that collectively, I guess 99% of the parties in this proceeding, or all but one, were able to come together with this negotiated lower carrying charge amount. It's definitely a positive for customers, but to call the reduction from weighted average cost of capital down to 2% illusory, I can't agree with.
Well, thank you once again for your insightful and detailed response. I appreciate that very much. And with that, Justin, I thank you for your testimony generally, and I have no further questions, Mr. Chair.
Thank you, Commissioner Keene. Commissioner Duffy, do you have any questions for this witness?
Thank you, Chair French. And some of the comments already made by Mr. Grady have answered several of my questions. So as we look forward, or let's talk, this event occurred in February and you met with the company again later on to talk about their upcoming winter plan. So were adjustments made at that time?
They were. So that the revisions, I'm just trying to, I want to make sure I get the gas utility correct. I mean, I know what they did, but I'm trying to think. Yeah. So the gas purchase plan for KGS for this upcoming winter had already been filed. I think theirs is filed. I think it's in my testimony, but it's in spring. It's in the spring to early summer. And so just shortly after the event, when everybody was still sort of trying to understand what had happened and accumulate, invoices and costs, and it was just very early. KGS filed their winter purchase plan for this upcoming winter, for the 21-22 upcoming winter. And at that time, there were not changes reflected in their purchasing practices, their contracting strategies, et cetera, for this upcoming winter. The first discussions that we had with them were You know, it takes a lot to change these plans. It's already been through our risk advisory committee. It's been signed off on by our management and, you know, et cetera. And so I think at that time, their view was we're going to continue to work hard to evaluate whether changes are possible for future winters, but we probably won't get changes done in time for this upcoming winter. And, you know, through that meeting and that discussion and then multiple subsequent discussions, we conveyed to KGS that, and CURB was involved in these discussions as well, but we conveyed to KGS that we would be very interested in any revisions that they could make for this upcoming winter to limit the possibility of recurrence of an event like this occurring if, you know, God forbid, we were to experience similar market pricing event for this upcoming winter. And there's limitations, of course, in terms of they have, you know, there's existing limits on their commission approved budget for hedging. And because we've still got the winter weather investigations open and we're evaluating the possibility for, you know, maybe significant revisions to future gas purchasing practices, et cetera. We didn't want to go too far for this upcoming winter without, you know, without having focus groups and without getting a commission ruling on the decision. So, but ultimately, within the bounds of the existing commission approved hedging budget, KGS was able to make changes to its gas contracting strategies and practices for this upcoming winter that would significantly reduce or mitigate their exposure to a recurrence of the gas market issues that we experienced during Winter Storm Uri. So if there were to be a repeat of what occurred with Winter Storm Uri this upcoming winter, KGS would fare much better, and its customers would fare much better than they did last year. So they have not been able to reduce or eliminate all of their exposure to the daily physical gas market through these changes. And you know, and to be honest, at this point, I'm not actually aware of a market solution or a hedging option that would actually allow them to reduce all of their exposure to the daily physical gas market. But within the bounds of the within the bounds of the commission approved budgets that have been approved so far, they have made some pretty substantial revisions and changes to this upcoming winter that would allow them to fare much better if something like this were to happen again.
Thank you. So this is the first time that the issue of securitization that we're able as a commission to act upon the legislation that was passed last session. What is it about securitization that makes it a better option than, say, what we were doing with Black Hills a couple of weeks ago?
So all of that, I mean, that's a big question. In other words, the specifics behind whether or not securitization, works or should be used, and what the parameters are, and why it's appropriate, and why it's better off for customers or results in lower net present value cost to customers than an alternative. All of that will be presented when KGS, as evidence, when KGS files for its securitization application, right? So So all we've done in this proceeding is say that we agree that it's a good idea that you ask for permission. We agree that it's a good idea that you provide all of the evidence that is necessary under the revised legislation that the commission has to then take in and rule on in order to make sure that securitization works for KGS, right? But based on what we have evaluated and looking at expected interest rates that we hope KGS will be able to utilize, and even a pretty conservative estimate of what those securitized rates would look like, as Ms. Buchanan discussed. Securitization just allows the utility to access low-cost financing for long periods of time, right? And lower cost financing than it otherwise would be able to. And so that's really why that's what's appealing about it from a consumer perspective, I think, is just that, it offers the ability to spread out the impact of these gas purchase costs over quite a long period of time at very low interest rates. And so, some of the downside to that, though, I mean, unfortunately, there's no easy answers in this industry, right? In this world, as you're well aware, Commissioner. And so there's no perfect answers either. There's just a better answer, or a better path or better course. So there are some downsides to securitization. So, for instance, the hearing that we were in a week or so ago in the Black Hills case, where they're not pursuing securitization, there are some carve outs and some customer protections, for instance, in that settlement that says, hey, if you can prove to Black Hills that you're a customer who's already paid all of your winter storm Uri costs to another Kansas utility, likely a non-jurisdictional utility, then you can have a waiver from this charge, and we won't charge you the winter storm Uri charges. That's in the Black Hills settlement, but that's not in the KGS settlement. And the reason for that is because that's our view was that would not be possible under the securitization statute, right? Is what one of the limitations and the requirements of securitization that allows the utility to access that extremely low cost financing is that everybody in the service territory that's a customer as defined by that law has to pay the securitized charge. And so you give up some flexibility, I guess is what I'm getting at. You give up some flexibility, but as a result, what you gain is very low cost financing. So it's a policy call. To a certain degree, it's subjective. There are other elements that have to be objectively or quantitatively determined, and that's all the evidence that the commission will have to receive and then rule on when the securitization filing is filed.
Okay. You've been with the commission for quite a while. Are you aware of any time where there has been a storm or an incident that in the gas industry that has resulted in a separate line item and fee to pay for the extraordinary costs? I mean, on the electric side, there's the occasional tornado, ice storm that plagues us, although it now appears we're not quite Tornado Alley anymore, which was good news to me. But are you aware of anything in recent history where this has occurred?
No, not in recent history. I'm trying to remember. There was an instance. I don't know why this recollection is so vague for me right now. There was an instance, and I didn't experience it directly, but I've read about it. But there was an instance that goes back just right before my time. I started with the commission in September of 2002, but there were some extraordinary gas costs. I believe, I think it was around the 2001 to 2003 timeframe it wasn't anything like this, right? But it was just relatively higher than normal or higher than recent history market price gas, in which I believe the commission required the gas utilities at that time to present a plan or to spread it out over several months. But honestly, I can't recall enough of the details right now. But no, there's never been anything even close to this in the natural gas industry, right? I believe Mr. Robbins' testimony has an example, a KGS witness that shows, the highest daily gas index prices of each of the major natural gas indexes that KGS relies on for its gas purchases in the last 10 or 20 years. And, there was an extremely cold weekend back in the 2011 to 2014 timeframe. I don't know if it was a weekend, but it was a day or two that caused, for that time, extreme natural gas price spikes into the $30 and $40 range. But and the specifics are in his testimony, but that was like for 1 day or 2 days, and nobody's ever seen in this part of the country. We've never seen gas prices even close to what were experienced during this event. And so, yeah, it's certainly unprecedented in that regard. The other thing I did just while I was listening to Mr. Francis' testimony earlier and your questions of him, I went and looked at, for historical context, I went and looked at how this level of gas costs compares to a rate case, for instance, or compares to the level of revenue that KGS was allowed during its last rate case, and it's extreme, right? So the 18 KGSG 560 RTS rate case was KGS's last base rate case, and that was the case that they filed in response to tax reform, the Tax Cuts and Jobs Act of 2018. And I looked at the staff settlement schedules from that docket, and the total revenue that KGS is allowed to recover for all of its non-commodity costs, right? So not the pass-through costs that go through the PGA, but the entirety of its revenue stream for everything else that it takes to provide natural gas service is around $325 million for a year, right? So if that doesn't put this storm and these purchase gas costs, the magnitude of it all into perspective, I don't know what does, right?
Thank you. Finally, this is related to the Attorney General. So you've been involved in the proceedings since day one, and the Attorney General has been as well. They have powers beyond what we have. Do you feel confident that the Attorney General is representing our consumers well in this particular matter?
Well, that's a very tough question for me to answer. What I would say is I certainly haven't seen anything that would lead me to believe otherwise, right? So they have been involved in this proceeding in every settlement discussion, every technical conference, every phone call in which all of the parties are involved. They certainly have been involved. I took their involvement in this proceeding to be mainly information gathering, so that they're involved, and so that they can stay abreast of the situation and the facts of these cases. And so, Commissioners, you're aware the commission ordered staff to provide all of the information that we have and that we have accumulated during these investigations with the Attorney General, and I know we've complied with that. And then additionally, I know that the Chief Litigation Counsel, Terry Pemberton, who you heard from earlier, I know that she engages in conversations with the other attorneys at the Attorney General's office. But I personally haven't been involved in those discussions. So I just have limited knowledge about, specifically what they are involved in with regard to the consumer protection statutes and whatever investigation or evaluation they're doing. And that's just because I haven't been involved personally.
Okay, thank you. That's fair. Finally, as I look at the checkerboard here of folks, we've got attorneys representing the company and their staff, attorneys and staff. We have representing all different types of entities, CURB representing residential small business. Let me ask you, and this is just kind of as Commissioner King uses to put a finer point, uses that phrase, who does staff represent in these proceedings?
So Miss Pemberton, I think, addressed this just at a high level and sort of with the legal, legal term when she entered our appearance, right? So she said, Miss Pemberton on behalf of staff and the public generally. And so that's who we represent. Staff represents ratepayers in the state of Kansas, but those ratepayers, it's tough. It's because we balance the interests of ratepayers and consumers' desires to have the cheapest electricity rates possible, with the reality that the absolute cheapest natural gas service or electricity that you can have for a certain period of time may ultimately end up in, being more expensive electricity or natural gas service. In other words, we recognize and account for in our balancing of interest the fact that you have to have financially stable and financially healthy utilities in order to provide reliable, safe service. So I personally, I view my job as very similar to the legal requirements and the legal standards of the commission and what the Supreme Court has said that, are the factors and the balancing of interests that has to occur during a rate setting proceeding, for instance. And that's mainly, the current ratepayers versus future ratepayers has to be balanced. Ratepayers versus the investors or the financial interests of the company, that has to be balanced. And then just the public interest generally. So, I don't know. our jobs aren't easy necessarily because everybody is always upset at us. You know, we're if we're doing our jobs correctly, then almost every one of those boxes on this screen we've disagreed with at one point in time or another during this proceeding, and we have. So, you know, we're analysts, we're not advocates. And so most every party that appears before the commission has a preset defined interest that their client is paying them to believe in, right? And that's just the reality, or advocate for. And that's just the reality of the situation of an adversarial administrative law process. But I don't have anybody telling me what my predefined position is before I come into a case, right? So my job is just to analyze the situation and as hard as I can and as zealously as I can, try to get to the truth and try to understand, get to the bottom of it and what's right and what's wrong, if I can call it like that, and just try to determine the best course of action that ultimately at the end of the day is going to serve Kansans the best, right? I'm a lifelong Kansan. I take this job very seriously. I'm passionate about it. And that's what I do. That's what staff does generally.
Thank you, Mr. Grady. I will say that because of this weather event, I know that staff has, it's been crushing for you to have to deal with all of this and in such a short amount of time with all your other daily responsibilities that are right at eye level and cannot be ignored. And it's been a Herculean effort for you all to reach this point, and yet we're not done. We're in process. And so I do appreciate the weight that falls on staff's shoulders to fetter out the truth. And so thank you very much for your testimony. I believe I'm finished, Chair French.
Thank you, Commissioner.
All right, I will endeavor to be quick. Get you all out of here because we're not taking a lunch break. We're going to finish up. All right, Mr. Grady, good to see you this morning.
Good to see you, Chair.
I'm going to try to paraphrase something I think you said earlier in talking about KGS's gas purchasing strategy and why it was prudent. I think what I heard you say is essentially at a very high level, KGS started relying more on market purchases at spot prices when their storage started reaching lower amounts. I think you mentioned that they'd gotten down to 3 days of storage left, and basically they needed to make a call as to what level of risk they were willing to accept, of how low they let those storage levels go, knowing that there was more winter to occur. Is that essentially what you were trying to convey?
Well, not quite. I mean, it may have came across that way, but there's the timing is a little bit different than that, right? In other words, obviously everything that KGS was doing during the event and leading up to the event is based on whatever information they have at the time and they can predict. It's based on their modeling of the expected amount of gas usage during a particular time. And then they're looking at their storage rights, their maximum ability to withdraw storage. They're looking at where their balances sit in relation to the gas purchase plan and how much they're supposed to have in storage at the beginning of the month and at the end of the month. And then it's not a lot different than dispatching power plants for electricity production, right? It's not. I mean, they have base load, certain resources that they rely on, and just based on the vagaries of the natural gas market and typical industry practices and standards, they set up those contracts well in advance. And so, a base load gas purchase contract, for instance, requires that the same amount of volume of gas be provided every day of the month, all month long. And so that's called for in the gas purchase plan, and they go through that, and all those details are there. So they did that. And that's sort of your base load. And then just like an electric generation dispatching model, you have intermediate resources. And for those resources, they call on those. They have first of the month call gas contracts where they have the ability, which are expensive contracts, by the way, and which you can't utilize. There's limitations as to how often you can use those during their year. But so then they start calling on those contracts, and that provides additional level of volumes, an additional level of resources. And then they're predicting and they're saying, how much storage can we take out over this period of time? And how much can we rely on that? And then once all of those resources have been exhausted, then you're down to KGS has peaking contracts, gas daily callable peaking contracts, which are based, it's a physical gas market, natural gas market, but the suppliers that have entered into those contracts with them have a legal obligation, a firm obligation to provide that gas when they call for it. But, based on specified notice and certain period of time prior to when you need the gas, they have to notify them that they need it. And then over and above that, then it's spot purchases that they make. But the specific details of the spot purchases that KGS made when they entered into those agreements and what the index prices were or the adders over those index prices, all of that, those specifics were provided in discovery in this docket and exists that could be put into the record if it was, desired to do so. But I don't think KGS made very many, if any, intraday spot purchases, right? Most of their spot purchases were 1 to 5 days during that period of time. And they're looking out and trying to figure out how much gas they're going to need and what they can provide from all those other sources. And then they're supplementing how much gas they're going to need.
So I guess what I'm trying to get across is they had basically exhausted it looks to me like the low cost gas they had available to them was base load, first of month, and storage. And they had basically exhausted base load and first of month. Storage was kind of their delta of how much are we comfortable using or not using. And then the less storage you're willing to rely on, or when you feel like you have to make the call that you can't keep drawing significantly from storage, then you have to move to the gas daily or the spot. Is that
right?
Correct?
Yeah.
Okay.
Yeah, that's correct. But it's just that, it's not, the specific details of when they reached at what point in the storm they had, 3.5, 4 days worth of storage left, which differs by contract, right? You can look at it in the total, but that doesn't really give you the real story because that's not reality. They have individual storage contracts, different places on their system. And if you look at that level of detail, they were at, there is a day that they were at the worst levels of their storage, and it would be maybe by the end of the 16th, or around the 16th or 17th, but it's not, and I just don't want to give you the impression that they waited until they got to that point and then said, oh, well, you know, we can't take any more out of storage. We have to go buy all of our gas on the spot market. It wasn't that, right? It was based on, you know, the information that they had at the time. They're looking forward, they're running models. They're saying, here's our most recent weather forecast, and this is what it says we're going to need in terms of you know, demand on the system. And here's what we can provide: storage and base load and first of the month gas. We're going to have spot gas. We're going to have additional gas, daily gas. We're going to have spot gas. And so they, you know, they made spot purchases. I mean, I'd have to pull it up, but I have a spreadsheet that has all of their daily gas purchases during this event from February 9th to February 21st. And there were days in there that they didn't make any spot purchases. But there were days where they made more gas daily call purchases than spot. But there are several days throughout that event that they made what's considered truly spot purchase gas. But the thing to remember is, you know, if you recall in my testimony, that pie graph that has the different types of gas, right? You know, the exact percentages that make up those different components are confidential, but what I said is, in aggregate, the two different components that make up everything they were exposed to for the daily physical gas market, the most expensive, you know, index price gas, about 32% of their gas. And what I said is, you know, less than 10% of that, of the total, was truly spot market gas. The other gas was contracted well in advance and was received as gas daily call gas, which is basically the same thing. It's got the same index price exposure, but it's got predefined and competitively bid adders, right? So if there's an adder over the index, that contract was selected via you know, an RFP and a competitive bidding process and well in advance. It's kind of like a peaking unit, you know, back to the electric dispatch world and that analogy. It's the peaking unit of their resource stack.
Appreciate that detail. And I know I'm being higher level than you, because to be candid, that's all I can handle. But I guess what I'm trying to get at here is, with complete hindsight, knowing, if my recollection is right, knowing that the next week, you know, temperatures warmed up dramatically. And if we knew exactly how much gas would be demanded at exactly which times, you know, it seems possible to me, with complete hindsight, they could have relied on different gas sources, could have maybe used up more storage, gotten closer to zero storage available. Obviously, that's not what they did, but based on the facts that were available to KGS at the time, the modeling that they had at the time, are you comfortable that the way they managed these resources and made purchases or withdrew gas from storage, that was prudently managed?
Yeah, but I am. So, you know, it sounds like we're going to get into a whole lot more detail and a better discussion about this the next time we're before each other on this, on KGS anyway, which I'm looking forward to. But I don't have the specific date right now in my mind, but there was the idea that you know, that by the 17th, that, or, you know, the 16th or the 17th of February, that well, it was going to warm up, and everybody knew it was going to warm up, and everybody knew it was going to get better. And, you should have just drawn your storage all the way down, and then you wouldn't have had to buy this high cost gas. And then you could have just filled in your storage later because it was going to warm up and the natural gas market was going to get better, and all the conditions were going to get better. That's generally the narrative as I understand it, or, based on the conversations that I've been involved in. And there is a, we'll find it and we'll put it in the record in the next proceeding, but there is an operational flow order or critical notice that was presented by Southern Star right around that time frame. Okay. And it basically, and it was going to last until I think the 20th or the 21st. And we'll get the specifics of that. But what you come away with when you look at that is that things weren't, you only know after the stock market bottoms, in March of 2020, you only know, look in July of 2020, looking back to say, man, that was a really good deal. Should have bought it then. But so it's easy to say on February 28th, looking back to criticize somebody's decision that they made at 7 o'clock in the morning on February 16th. Just, maybe 12 hours after the commission issued a once in a lifetime order that said, do whatever it takes to keep the natural gas on and keep people warm and safe in their homes. So that's when KGS made the decision to purchase gas for gas day 17 for at least a portion of it, right? And when we asked them, why'd you do that instead of relying more on storage? And there's a single spaced 4-page answer that the people that were responsible for that decision of how they explain what their decision was. And what they're saying is we had very low storage balances down to 3 to 4 days. There was still a lot of uncertainty in the natural gas market with regard to how much gas was going to come back online, when it was going to come back online, how much additional of our supplies were going to be cut from force majeure. And so I don't know, my take after reading all of that and my evaluation of the situation is that I can easily see how and why they made the decision to continue to purchase gas during that time, because hindsight is 2020. And, I just know what an emergency situation it was, and how little knowledge there, or how little insight there was as to what the next shoe to fall or the next issue to come down the pike. And I just think that there wasn't certainty necessarily that it was going to warm up. There wasn't certainty that all the gas was going to flow, and we'd be able to, increase our storage balances. And the other thing I know is that from conversations with the gas purchasing people over the years, they live in fear, constant fear of somebody second guessing their decisions, right? And it's because the product that they buy, that they're responsible for supplying to their customers, is such a volatile product historically. And so they live and die by their gas purchase plans. And so because we presented it a year in advance and we talked to you guys about it and we told you what the risks of it were, and this is what we follow. And so, you know, I'm not surprised at all by the fact that once their storage levels got to a point where they're lower than they're supposed to be at the end of March for some of those fields, right? When you get to a point where the gas purchase plan says I'm supposed to have this amount of gas in storage by the end of this month, because we don't know what the weather's going to be in March. There's still quite a bit of winter left. It can get pretty cold. You know, the gas purchase plan calls for around 20% of storage to be left by going into March, right? And so I just can see how approaching the limits that they were, I can see how they made the decision that they did and why they made the decision that they did. And you know, I think the standard is prudence. It's not perfection, right? The standard is what would a reasonable person do under those circumstances with the information that was available. At least that's my interpretation, non-legal interpretation of what the standard is. And I don't know, just all the conversations I've had and everything I've read, and also with the knowledge of, you know, knowing how every other gas utility in the state behaved and the decisions that they made during that period of time, I think it was reasonable.
I appreciate that. You know, I know it's an issue that's going to be addressed later in the proceeding, but it's absolutely an issue in the settlement before us. And I think that's why it was addressed in your testimony. So I appreciate that extra detail. Let's move on to a little different topic. These questions are going to be a little quicker, more just for confirmation. You cited Ms. Buchanan's estimate of monthly bill impacts. It's the number we've talked about of somewhere between $5.07 to $9.30 for a typical residential customer per month. And your testimony says that range depends on the maturity of the securitized bonds, or how far out we go with these payment plans, you know, 5, 7, or 10 years. Does that range also take into account amounts that could be received from non-sales customers, or would those amounts received from non-sales customers lower that range farther? I mean, could it be more like $4 to $8 or $3.50 to $7 if those full amounts came in?
Yes. Yeah, you're absolutely right. So those numbers do not account for an offset that would occur for any any negotiated gas cost penalty or otherwise amounts paid for by non-sales customers. At least I want to be careful. I mean, I'm 95% certain that that's true. That's not my work paper or my work directly, but I'm almost certain. I'm almost positive that that's the case.
And that those offsets potentially could be pretty substantial. I think the number I've seen is about $99.7 million of purchased gas costs, plus their amount of carrying costs. So it could reduce the extraordinary costs flowing to sales customers by as much as a quarter to probably not quite a third, but more than a quarter, correct?
Yeah, I can't recall. So the only other, the number that's sticking in my head is like $86 million, right? Because there's the compensation back to the customers that provided long gas on the system. And so it's that you just want to make sure it's the net of those two. It's not the close to $100 million penalty amount. It's the net of the two is what KGS would actually receive. So I guess if you think about that, it's about a quarter, I think, right?
And that's
So, yeah.
assuming that the full amount was actually able to be recovered.
That's right.
Okay, that clears up the potential bill impacts issue that, the range could even be lower, just depending on what happens. Trying to figure out what else I want clarification of here. Well, I guess I'd like your take or confirmation, just very briefly. I asked Ms. Buchanan about the delta between, sort of the estimated actual debt costs over these 2 years of 1.56% versus the 2% in the settlement. And, we talked about that was to provide some allowance for risk because that's a floating interest rate. I think that is what you talked at length about when you talked that there is some reasonable cushion that has to be provided to financing. Is that correct?
That's correct.
Okay.
Right. I mean, I think I mentioned in my testimony the fact that there is risk, or that is a variable rate. So that's the problem, I think, with with the number that Mr. Gorman used, is that he basically treats it like it's a fixed rate in the calculation of that number. I mean, that's not a criticism. He, I think, acknowledged the fact that it's a floating rate, but if we don't know what the rate ultimately will be. But that's, I don't know whether that's the more important factor in my mind, or the fact that there's a cushion that is necessary. I know the kind of pressure that One Gas's credit rating, credit metrics are under right now, right? I mean, the fact that they received a 2-notch rating at one time and they still are on negative, credit watch negative today, is very significant. I mean, that's, Jeff might be able to provide a better, I don't know if his memory, if I cannot recall the last time that a regulated utility in the state has been downgraded by 2 notches at one time. The last time that occurred might literally have been Western Resources back during their extreme financial difficulty and under David Wittig. That is such an extremely unusual occasion. And so, I just have not been, I don't know. So I think the cushion aspect of it is important as well. And between those two factors, that's what I think the commission should rely on in assessing the reasonableness of that carrying charge. I just don't think it's reasonable, or a reasonable standard, or even a reasonable suggestion, personally, that it should be the exact dollar amount of the interest expense that's stated on the financial instrument that the company is paying. That's not how rate making works, and it never has been. So,
and that's just for my clarification, because when we do a capital structure in a rate case, we do take their actual cost of debt. But the difference here is that this is a short-term floating rate instrument. Is that right?
Yeah. So there's a lot of differences, right? I mean, for instance, in Kansas, we don't recognize short-term debt costs at all, right? And so there, in a rate case is, there are more sort of theoretical elements of it, as you're aware. I mean, there's a portion of that capital structure that's compensated at the return on equity or the cost of equity of the utility, which is a big, a cushion. When I say a big cushion, relatively speaking, it's half of the capital structure. And so the utility has a lot more flexibility and cushion to ride through changes in interest rates, whether up or down. And then, I think importantly too, is that we don't recognize the cost of short-term debt in the capital structure at all. So any capital that's being financed in the short term with short-term debt, but then in that, the interim period between when that short-term debt is, the costs are incurred on that and the infrastructure actually goes into rates, that's another cushion that exists. At the end of the day, there are just realities that these utilities have to face. And, bond rating agencies and bond investors are nervous people, right? They are nervous. It's nervous capital. They're very risk averse entity and very risk averse markets. And they want certainty that a utility will be able to recover the amounts, that they'll have certain cash flows, that they'll have certain timing, that they'll have certain cushions. And so, those are all important considerations as well, I think.
One more question. It's a question I asked Ms. Buchanan, but I want to get your take on it because I think it is one of the most important questions for this specific settlement agreement. Ms. Buchanan confirmed for me that, this $366 million of extraordinary costs, it includes, all the gas costs that were necessary to keep the entire system balanced, even though much of that gas ended up being used by non-sales customers. And I'm going to paraphrase hopefully correctly, but I think in her opinion, it would be fair to pass this entire amount along to sales customers, in the event that it couldn't be recovered from third parties. It would be fair to pass the entire amount along to sales customers because this was the amount that was necessary to keep the system balanced, to keep gas flowing, to prevent enormous property damage, to prevent loss of life. One, do you think I've correctly paraphrased that? But two, do you agree? And how do you view that issue of whether this entire amount would be just and reasonably recovered from sales customers, irrespective of what recoveries KGS can receive from non-sales customers?
Well, I'm glad to see that you reserved the most difficult question of the day for the last one. So thank you for that. No, that's a big topic, right? It's a big question. And I know CURB will may have a different view or will have strongly held views one way or the other, on that issue. But, from my perspective, I think that the company should have and should continue to attempt to collect from transportation customers, from marketers that represent those transportation customers, the portion of gas, the cost of the gas that those marketers and transportation customers were legally obligated under the tariff to provide for their customers, right? And the fact that that KGS did that and kept the system in balance, and the gas was required to be delivered by those marketers and those transportation customers. It wasn't delivered. And accordingly, I think transportation customers and marketers ought to pay for that gas that they used on behalf of their customers and or that was required to be delivered and wasn't delivered, just for fairness and equity purposes. And appropriate cost allocation standards and everything else. But ultimately, if for some reason they were not able to recover those costs from those other parties that that were the responsible parties, that they should be able to receive recovery of from those other parties, then the only other option would be to require the company to take a disallowance, or to require the company shareholders to eat those costs, right? And I don't believe that would be equitable or appropriate. And I say the only other option to sales customers paying for them. And so I would support, ultimately, I would support sales customers paying the entirety of the purchase gas costs if the effort to recover those costs from marketers and transportation customers were to fail. And I would, because I don't think the company did anything wrong. I don't think they were at fault at any time during this event. They were caught up in a market-wide swath of, a major swath of this portion of the country and other portions of the country. Market prices did what they did, and they responded the best they could. And the specific details of how they fared versus how Black Hills fared, or even not-for-profit utilities whose sole job it is to buy gas at the most reliable and affordable prices that they can, right? You can compare them to other entities like that. And I just think that they did the best they could at the time. And I think it'd be, I wouldn't personally support the recommendation that KGS and their shareholders should eat the costs that transportation customers and marketers didn't pay, because I think their actions at the time were necessary to support the system reliability and stability and provide continued gas service.
I said that was the last question, but it made me think of another, which is, and maybe I'm getting into the waiver docket, and if so, you can tell me to just save it for the next hearing. But should there also be some requirement or showing that KGS prudently tried to recover those amounts from the third parties before they would be made whole by sales customers?
I think so. I mean, I think that just falls under the, in my mind, reasonable, efficient and sufficient service, prudent, reasonable management, that's doing everything it can to provide just and reasonable rates. If they aren't attempting to recover those costs that they believe other entities are responsible for incurring or causing, then that would be a problem in my mind. And then potentially you are looking at a prudency issue or a disallowance issue. But it's, it shouldn't be, I know it's not a surprise to you or the commissioners, because we discussed it in other hearings and in other proceedings. But, our staff's view from the beginning has been that if there were costs that were incurred by or that were caused by, or that were appropriately allocated to non-sales customers in another class of customers, then our view from the beginning has been that each gas utility, not just KGS, but each gas utility should use the provisions of their tariff, the penalty provisions of their tariff, to recover those costs. And it's just a cost cost causer, cost payer, or appropriately cost allocated type of a cost of service principle. And that's always been our view since the beginning. And so, we think that they should do everything they can to try to recover those costs from the non-sales customers. But at the end of the day, if they just absolutely can't, then at that point, the only other option in my mind that would be just and reasonable would be for the sales customers to pay for those costs.
Thank you. If there are no further commissioner questions, which I'm not seeing any, I'm going to turn to Mr. Flaherty for any redirect.
Actually, I believe that'll be me.
Oh,
Chair.
Ms. Pemberton for redirect.
Okay.
Unless Jim wants to take it.
Go ahead, Terry.
I do have a couple. I'll try to keep it brief. So, Justin, you had a line of questioning, I think, from all the commissioners at this point with respect to the carrying charges, that 2% carrying charges that's part of the settlement agreement. And I just wanted to talk about that a little bit more. And I want to discuss if there wasn't an agreement. So the 2% is inexistent because KGS is choosing to securitize, correct? Let me rephrase that. That's a poorly worded question. If KGS opted not to securitize, would those carrying charges potentially be different?
Yeah, that's a good question. So if KGS was going to seek to recover these costs over a 5 or 7 or 10-year period of time, right, in order to match come close to the per bill amounts or the customer impacts that are in the settlement, then I don't think it's likely at all that we would have carrying charges in the 2% range. An example is, and the numbers would be probably a little different because each gas utility is different. But, I think an appropriate comparison would be to the Black Hills settlement that's before the commission right now. So that's a 5-year plan. It's got a lower carrying charge up front. But then once the recovery period starts, I believe the carrying charge is 5.7%. And so, it's just a reality of the fact that the longer you stretch out that cost, absent securitization or some other form that gets the costs off the books of the company, the cost is going to go up. And there are necessarily going to be additional equity costs and additional equity that's used to support that borrowing and that debt level. And that's what ultimately results in those higher carrying charges. So yes, I absolutely agree.
Thank you for that. You also had a line of questioning from Chairperson French about the storage levels and how KGS managed its storage. And I do have one brief follow-up on that. Without going into confidential information, and you touched on this very briefly, but I would like for you to expand upon it a little bit more if you would. How did KGS's use of storage compare with the other gas utilities and the other dockets that you've investigated today? Was it comparable? Can you give us a little bit more detail on your views on that?
Yeah. Yeah, probably not with as much detail as I generally hold myself to the standard of. I actually can't recall. I can't recall enough to be able to provide you the kind of answer that I'd like to on the record. I know Black Hills and KGS are the two entities that I'm the most familiar with right now. KGS is the one that I'm the most familiar with right now. KGS is the one that I'm the most familiar with right now. KGS is the one that I'm the most familiar with right now. KGS is the one that I'm the most familiar with right now. KGS is the one that I'm the most familiar with right now. KGS is the one that I'm the most familiar with right now. KGS is the one that I'm the most familiar with right now. KGS is the one that I'm the most familiar with right now. KGS is the one that I'm the most familiar with right now. KGS is the one that I'm the most familiar with right now. KGS is the one that I'm the most familiar with right now. KGS is the one that I'm the most familiar with right now. KGS is the one that I'm the most familiar with right now. KGS is the one that I'm the most familiar with right now. KGS is the one that I'm the most familiar with right now. KGS is the one that I'm the most familiar with right now. KGS is the one that I'm the most familiar with right now. KGS is the one that I'm the most familiar with right now. KGS is the one that I'm the most familiar with right now. KGS is the one that I'm the most familiar with right now. KGS is the one that I'm the most familiar with right now. KGS is the one that I'm the most familiar with right now. KGS is the one that I'm the most familiar with right now. KG there is the next phase of this that we're going to move into is the Atmos Energy discussion and, their financial plan. Atmos utilized storage during the event as well. But there are, their exposure or their experience and their utilization of storage is going to be different on a day-by-day basis compared to KGS or others. I think what's fair in my mind, if the commission is going to look at and compare, the way the gas utilities have used storage, the way I've been looking at it is sort of in aggregate from the period of February 9th through the 21st, just so that I have either you can look on a day-by-day basis if you want, or look in aggregate from February 9th to the 21st. But that's how we've been evaluating it, just so that we're looking at a consistent basis of comparison between the three utilities. The Atmos numbers aren't top of mind for me right now at all. But for Black Hills, Black Hills did utilize more of their storage. They utilized their storage, I would say probably close to equivalent to the level of KGS in aggregate. But I know KGS, for instance, the numbers, I looked at this morning, right? KGS, the expectation in their gas storage plan was that they would rely on storage, 103. No, I don't want to go into the specifics. I'm sorry. I think that is confidential. So, KGS roughly utilized storage twice what they expected to. They utilized double the amount of storage they expected to pursuant to the gas storage plan, right? And so Black Hills, I think it was pretty close to that in aggregate. They too, each of the gas utilities did what they could to draw more down from storage if they could. But Black Hills exposed themselves to some pretty significant interstate pipeline penalties by overrunning their capabilities of their storage during the event. And fortunately for them and their customers, those interstate pipelines ended up waiving those penalties. But that's a major difference between KGS and Black Hills, in that I don't think KGS was exposed on any one day in particular during the event to beyond their maximum daily withdrawal quantities. But so that wasn't a very good answer, unfortunately, but I just can't recall the details right now.
That's all right. It was a decent answer. How's that? I do have one final question, and this goes to a question that Commissioner Duffy asked about who staff represents in this proceeding. And so, obviously the public generally is who we represent. I guess to fine tune that a little bit, do you consider the interests of the transportation customers to be part of that public interest or public generally that you represent in this proceeding?
Yeah, absolutely. Absolutely. We'll get into more detail when we get into the waiver proceeding, right? But,
right.
I spent a lot of time and as did, people that report to me, and as did KGS, refining the numbers and the penalty amounts that are in the negotiated gas cost penalty amounts that are in that waiver proceeding. And when I say refining, each time that we did that, the result was lower and lower penalty amounts for marketers and for transportation customers. And, that if if our interests were solely to minimize the costs of sales customers and residential customers, for instance, or small commercial customers, then we shouldn't have we shouldn't have been involved in those discussions and in that work. And our view should have been just request a waiver of the multiplier and bill the penalties at the Southern Star Index rate. Just do that, right? Because the result of that is $117 million in penalties, or maybe ask for a 50% waiver of the maximum penalty amount and bill $400 million in penalties, and then sales customers don't have to pay anything. But of course, that was never, we wouldn't have ever even contemplated taking a position like that, because transportation customers are extremely important to the Kansas economy and to the public, or an extremely important element of the public interest, right? There's schools, their hospitals, their manufacturing firms, some of the largest employers in the state. So our interest, people will have different views, and reasonable people can have different opinions about how well of a job we did. But our interests were always in trying to treat everybody fairly, and and come up with a number that was reasonable and treated everybody fairly.
Okay. With that, Chair French, that's all I have. Thank you.
All right. I think that brings us to the conclusion of Mr. Grady's testimony. Mr. Grady, you may step down virtually. And we are now at the end of all witness examination. So a brief reminder, we do have a post-hearing briefing schedule for this issue. And I believe those post-hearing briefs are due January 5th, 2022. And a commission order on this financial plan settlement is also due by February 8th, 2022. Are there any final matters that need to be considered by the commission before we conclude?
Nothing further by KGS. Thank you.
Hearing nothing further, this will conclude our hearing on KGS's financial plan in docket number 21 KGSG 332 GIG. And we are adjourned at this time and off the record. Thank you all very much. Take care.
Thank you.